for being so prompt. We are going to begin as a subcommittee until we form our quorum. Just a couple of bits of housekeeping. The two committee bills pertaining to non-substantive revisions of deadly weapon statutes, SB 1080 and 1115, have been removed from the consent calendar, so we'll be hearing those in today's hearing. And then just one bill has been put over until next week, and that would be SB 1411 by Senator Simitian. And we are going to ask Senator Ashburn to join us, to be followed by Senator Flores. Senator Ashburn, you have SB 1055.
Thank you, Mr. Chair and committee members. This measure deals with background checks for the under the authority of the state's chief information officer. They're already in the consolidation effort that has been achieved from various departments. The Department of Corrections, from Health and Human Services, from the Lottery, the Franchise Tax Board, the DMV. All of these separate authorities now are residing in the State Chief Information Officer. What this bill attempts to do is to have the same background check requirements that already exists in law in each of these various separate entities consolidated under the new auspices of the State Chief Information Officer, so that the data, some of it very sensitive, that is dealt with by the state's Chief Information Officer is secure, and that the people who might have access to that are subject to background checks. That's the purpose of the bill, and so I present it to you and ask for your consideration.
Thank you, Senator. Those in support?
Thank you, Mr. Chair and members. John Dickinson, Director of Government Affairs for the Office of the State Chief Information Officer. Since the creation of our office about 2 years ago, we've worked extensively with the administration and with the legislature to find places where we could consolidate, reduce redundancies, and achieve ongoing baseline IT infrastructure savings. One of the primary places you find that is in the data center. By moving a lot of the servers and storage to the state's data center, we are able to achieve a lot of savings in energy and just cost in general. In order to do that, we need to be able to have background checks for those employees, roughly about 400 out of our 1,300, who have access to the confidential information, like Health and Human Services, health records, FTB's tax records, DMV, all their transaction information. We have a lot of Social Security information as well. So this is critical for us to be able to move large organizations such as CDCR and Health and Human Services over to our mainframe network.
Very good. Thank you. Anyone else who would like to speak in support of the bill? I know we have some listed opposition. Anyone here to speak in opposition to Senator Ashburn's SB 1055? Please join us.
Good morning, Mr. Chair and members. Valerie Small-Navarro with the American Civil Liberties Union, and we are in opposition. We have talked with the author staff and the supporters, and we have raised a number of concerns in our letter, and I'd like to sort of reiterate those because I think it's important to deal with them. I'm not sure the committee consultant proposed some questions. I don't know that they've been dealt with. The prime issue is, first of all, there's a very open-ended background check in this bill. It doesn't seem to say, like, which crimes, why do we care? It could be, petty theft 20 years ago of a bicycle or something. So we really need to focus the list of crimes that are relevant to people accessing confidential information. And there was a discussion to narrow that list to the crimes that would be relevant for people who who access financial information. So I would suggest that that's an appropriate list. I mean, people who are currently accessing individuals' financial information have to meet a fairly high standard, and I would suggest that's an appropriate standard. In addition, there's some issues about due process rights. For example, there does not seem to be an appeal process in the bill currently. In addition, part of the due process rights would be to actually get a copy of your rap sheet so that you could see to make sure you're the right person. Also, there's a provision that says anyone who has access to the information shall go through this background check. If you can imagine, what does access to mean? So those are the issues we've been raising. I think I'm trusting that we can work them through, but I think they're fairly significant and wanted to raise them for the committee. Thanks.
Thank you for your comments. Before you take off, how do you... Can you get even more specific about what you think the unintended consequences of the overly broadly concept presently before us?
Well, I think, and that, I mean, to be very honest, I mean, that is the real issue. Like, is everyone, if you have a conviction of a crime 20, 30 years ago that's not relevant to your ability to actually perform that task, that's a problem. If you even, the notion of running background checks, I think it's kind of become fashionable these days, but I think if an employer, upon the interview process, goes through appropriate questioning, and they can question about convictions under current law, so it's not that individuals cannot question, but I don't know how appropriate it is in the first place. Sometimes, if you've had something way long ago, why is it relevant today? If you've since that time you've whatever, you've rehabilitated, you've changed your life, you've turned it around. So anyway, so I appreciate the question, because we do have the fundamental question: are background checks appropriate in the first place? Does it make sense in this particular situation? And
could you point to any precedents in current law with regard to the individual who is having his or her background check pursued to get a copy of that record?
Yes, it virtually, and I don't have the exact number of data, but basically every single bill that's been coming up in this area, the requirement that the individual have a copy of their rap sheet has been inserted. That is part of the due process protections. Because, of course, you could be the wrong person. The rap sheets aren't always 100% right. You want to be able to take a look and say, hey, that didn't happen, or if it did happen, I went through a deferral, or I had some other remedy in front of me.
Thank you. Anyone else who wants to speak in opposition? Senator Ashburn, any argument you would like to make as to why someone should not get a copy, and why this should be different from any other
Mr. Chair, I want to remind the members of the committee that there is nothing new in this bill. This authority for background checks and for the denial of employment based on a bad check already resides in each of these various and different departments and agencies. With the advent of the Chief Information Officer and the consolidation into a central data center, this authority now needs to move from those several and different departments and agencies to the Chief Information. That's what this bill achieves. There's no expansion of authority. There is simply the movement so that we can achieve, as and you know well, the budget committee has, and the legislature and the governor have asked for savings by consolidating and streamlining our functions in state government. That's what this bill helps to accomplish. And certainly, I know the members of the committee will be very sensitive about the fact that information retained in the data center, in many instances, has very strict federal guidelines and requirements attached to the security and the safety of that information. We've got to assure that those employees that might have access to that are sufficiently checked so that we can comply with federal requirements as well as maintain the essential confidentiality of Californians. And so I don't view this bill, Mr. Chair, as along the same lines of background check measures that have come here many times, including some that I've brought in the past.
So it's not your intent with this bill to deny the applicant a copy of the rap sheet?
No, with respect to due process, this is my personal view as the author of the bill, and realize this is an administration-sponsored bill, and so I would want to defer to their wishes on this. But as far as I'm personally concerned, the employee should have access to whatever information may be obtained. There ought to be an appeals process. It seems to me that seems only fair. I don't want to unnecessarily burden the department, but on the other hand, I think employees ought to have access to information that may have caused their denial of employment, or maybe not denial of employment, but access to this particular sensitive area of the functions of the department.
Did you want to respond?
Yeah, that'd be great. Thanks. It is not our intent to not disseminate information. The language, as you see, is really a reflection of one of the most recent statutes that was implemented for DMV with regards to background checks. And as one of our clients, or our customers, we look to them and their statute first to see what that looked like. And it's a very flexible statute, and we feel that's important for us to have as well, as federal laws change, as state laws change, as technology environments change, and as our customers change. As we bring new people on, we need to make sure we have the ability to change in policy to make sure that there is a nexus.
Right. So given that that's not your intent, you could be agreeable to some language we could provide so we could clarify that in an amendment that the applicant would not be denied access to
We'd be happy to work
information.
with the committee. I'm not prepared to take any amendments today on behalf of the administration, but we would be happy to work with the committee.
Okay, so I just want to clarify then that there's no objection that this issue of due process that's been pointed out, there would be no denial of that information. In fact, it would be required that the applicant would receive that information.
Mr. Chair, I would suggest this bill does go with your permission to appropriations. Next, we would work between now and then to come up with something that would be acceptable to everyone. If it is not, and you want to bring the bill back to the committee, again, I want to make sure that everyone's concerns are accommodated.
Ms. Molinaro, you have a comment?
If I might, I realize we're focusing on one aspect of due process, which is ensuring that the individual gets the rap sheet. But there's more. I mean, the idea that there be an appeals process in place. And I hear that you're saying, well, this is based on what the DMV does, but it's not in the statute, so it's not required as far as I know. So I think there's more that needs to be worked on. The language, as I mentioned earlier, access to is a very broad term.
Well, I indicated, I believe, that I'm, as the author, willing to talk about a due process, appeals process for the applicant, in addition to access to the record.
Very good. And then also,
if I could, on the access question, we also want to make sure we're flexible on that. I mean, Senator Huff, you did a tour of the data center, and I think you're fairly aware that you can't get into that facility without some type of clearance. And so to actually be able to physically access or administratively access these machines, it's not just any person going in there.
and then if I could have your response to the point that we could have a very minor historic crime on someone's record.
And in our view,
with regard to this being overly broad.
Right. Well, in our view, keeping this flexible allows us the ability to make sure that we can have exemptions for those crimes that could have been committed long ago. I mean, if you get too prescriptive in the statute, then exemptions become more difficult.
All right. I would prefer, rather than trying to do this on the fly today and not get the refinement just right, and at the same time letting a bill leave the committee that I know is not completed and we're going to trust that it's going to get done in the future. If you had a double referral to another policy committee and you are under the gun with regard to timeline because you also have to go to the fiscal committee, I might have another opinion on that. But given that there's not a time crunch, how about if we work together over the next week and that we'll get this out of this committee next
That's
week?
fine.
All right.
Absolutely.
Because I think there's no objection to what you're trying to do here. We just want to get it right.
Good. I agree
Any
with you.
committee member comments?
Only the question about how Senator Huff managed to get into the data center, given the stringent criteria that's
Given his background.
I used your credentials, Senator.
Very good. Thank you,
Mr.
Senator, for
Chair.
working with us. Senator Flores, welcome. Our item number 1, your SB 834.
Thank you.
Mr. Chair and members, we do, I would appreciate, I'm going to give a brief presentation, but we do have some witnesses that have traveled some distance, and I would appreciate having them be able to say a few words. Members, I'm pleased to present Senate Bill 834, dealing with protective orders. The bill, very simply, would permit a court upon conviction in a case where the victim is a minor to prohibit the defendant or persons acting at the direction of the defendant from making contact or communications that annoy, harass, or threaten the victim or the victim's family or co-workers. And in addition, the bill would allow a court to permit legitimate communications with the victim. However, we do know that your staff, Mr. Chairman, has worked very diligently with our staff. We very much appreciate it. We know that we have narrowed the scope of the bill, and we've done some items in terms of exempting the defendant's attorneys. And, of course, there's jurisdictional issues which we believe the courts will figure out. But we also would like, Mr. Chair, to make sure that we have in this bill, as we discuss it, the ability to have courts define friends as well as much as possible, and we would like to make sure that leaves us the genesis of this particular case. And I'd like to say that we're very proud to have the support of the California Sheriff's Association and PORAC, and we do have Gloria Allred, an attorney, here as well. I'd like her to present the reason for the bill, and Autumn Ablin, who's been gracious enough to join us here in Sacramento to give us some testimony as well.
Thank you. Ms. Allred, welcome.
Thank you, Senator Leno.
If you could just hit your red button, we'll get you mic'd.
Thank you. My client, Autumn Albin, and I are here today to address the important issue of how to stop the harassment of child crime victims after the perpetrators of the crimes against them are convicted and sentenced for those crimes. Last year, Anand John, a celebrity fashion designer, was convicted of numerous felonies against young women who were or aspired to be models. He was convicted of forcible rape, attempted forcible oral copulation, and attempted sexual assault. One of his victims, Autumn Albin, who is now age 18 of Riverside County, but who was a minor at the time of the offenses, is here with me today. In reference to Autumn, Mr. John was convicted of 3 felonies, including 2 counts of a lewd and lascivious act with a child aged 14 or 15 and contributing to the delinquency of a minor. Autumn testified at Mr. John's trial and spoke at his sentencing, delivering a very emotional victim impact statement. During the trial, her name was not made public since she was a minor, and the court protected her privacy. In addition, she did not do any interviews, and her face was not televised at the sentencing. It was therefore very upsetting to Autumn to learn that after the conviction and sentencing of Mr. John, that persons appearing to act on behalf of him contacted a number of her, quote, friends, end quote, on her Facebook page and texted some of her friends, providing her full name and asserting that Autumn had lied and that as a result, Anand John had received a life sentence in prison. A short example of what was texted allegedly by her investigator was, quote, if you are getting, or his investigator, quote, if you are getting this text, you know Autumn Albin. Her lies caused Anand John to get a life sentence. There is a reward of up to $100,000 for the truth. If you have a conscience, please contact investigator Agaki, 323-466-4837, 323-466-4837. Anand John case, jhvinvestigations.com, end quote. This attempt by John's supporters to attack her after a jury found him guilty of serious crimes against her was very upsetting to Autumn. It took a great deal of courage for Autumn to testify both at the grand jury and at the trial. It was very embarrassing to her as a teenager to have to testify about the details of what Mr. John had done to her, and many in the courtroom cried as she gave her victim impact statement and discussed the emotional toll that the crimes that he committed against her took on her. However, when the sentencing was over, Autumn felt that she had done the right thing and that she could now go on with her life. When her friends began to inform her, however, of what John's investigators had posted on Facebook and were texting her friends, she realized that the nightmare was not over. She was very upset because many of her friends on Facebook who saw the investigator's message were complete strangers to her. She had never told them that she was a victim in a criminal case. Her privacy had been completely invaded, and her full name was being disclosed without her consent. In addition, false statements were being made about her. Particularly upsetting was a texted statement to her friends that, quote, her lies caused Anand John to get a life sentence, end quote. First, the jury believed that she told the truth and therefore convicted Mr. John of crimes against her. Second, Mr. John did not get a life sentence because of Autumn's testimony. He received a life sentence because he was convicted of crimes against her and against other women. Finally, offering a reward of $100,000 for the truth seemed like an effort to find someone who was so desperate for money that they would come forward and say whatever Mr. John's supporters wanted them to say. Autumn felt that she was being unfairly targeted and harassed and came to me to find out what she could do about it. I immediately sent a letter to Mr. John's investigators warning them to cease and desist, but received no response. After that, I spoke to California Senator Dean Flores, distinguished majority leader of our state Senate, and asked him if he would introduce new legislation to stop the harassment of child crime victims by defendants or their supporters after the defendants were convicted of crimes against the victim who was a minor. My analysis of current law was that it was inadequate to deal with the problem faced by Autumn, and I discussed with him changes that I felt needed to be made to provide new protections for crime victims who were under the age of 18. Fortunately, Senator Flores immediately responded and took quick action to formulate SB 834. Autumn and I want to express to Senator Flores our appreciation and great respect for his important leadership on this important issue. We look forward to doing everything possible to help it become law. Thank you very much. Thank you. And Autumn has a very brief statement.
Thank you, Ms. Allred. I want to welcome Ms. Elbon to our committee. I understand this is your first time at the State Capitol?
Yes, thank you.
We want to make it a positive experience for you.
I hope so. When I think about what I've been through, I feel it's ironic. I went around thinking, finally, the nightmare is over, and in reality, it was just the beginning. All throughout high school, I had managed to leave this horrid memory in the dark, because how many teenagers really want to tell their fellow classmates such a thing? None. It's embarrassing and heartbreaking. The day I saw the page on Facebook, my heart dropped. I began to be questioned about my personal business by people I barely even knew. The text message the investigators forwarded ended up being sent to me. I had no idea what to tell my friends and acquaintances when they asked what investigators were asking. My privacy was invaded, and I was starting to crumble. I had really just wanted it to be over with, but after I met Ms. Allred, I decided that I will not be intimidated into keeping quiet. I will continue to fight so no other victim will have to be put through what I had to suffer, and so that no one will get away with this again. Thank you.
Thank you, Ms. Elbon, and thank you for the courage it takes for you to be here today. We appreciate it. So the analysis, of course, let me ask if there's anyone else who would like to speak in favor of the bill, and if anyone would like to speak in opposition.
Chairman and members, Francisco Labaca on behalf of the American Civil Liberties Union. First, let me say that I appreciate the changes that have been proposed. I think they move in the right direction. The bill, as it first came to committee, was rather broad. I'd never seen anything quite like it. That said, I think we do still have some questions in terms of what is trying to be accomplished here. The first one is the obvious. I mean, you know, the law already provides a variety of situations where you get protective orders and stay-away orders for people who have been convicted of a variety of different crimes. People on probation, people on parole, have stay-away orders all the time. The question is, what is the reach of those kind of stay-away orders? As I read this bill, at least as it comes to your committee, it's a lifetime prohibition. And so I think this first question is sort of the constitutional question as to what is the jurisdiction of the court to individuals who no longer are on parole or probation. And that's a question, I think, that is a relevant question that needs to be decided by the committee. I think it does raise some problems. Two is sort of the reach of the legislation. You know, annoying somebody, I'm not quite sure. I mean, since the bill, as it came to committee, it really didn't have a chance, since amendments were just, I saw these amendments yesterday. There are a variety of other statutes in the books that deal with the kind of protective orders that are issued. You know, where are we going with these kind of sort of, you can't annoy somebody indefinitely? I'm not quite sure what that means. Thirdly, it's the question of, and perhaps Ignacio will speak more to it, to the issue of issues on appeal. Folks have a right to investigate. Folks have a right to, defendants' attorneys have a right to get their investigators to go out and find out if, you know, to investigate the case for purposes of habeas, for purposes of post-conviction situations, and put, you know, what kind of restrictions can you actually put on those individuals to engage in what they're supposed to be doing. Obviously, you can't do anything to threaten, harass individuals anyways. But, you know, what is the reach of that? And thirdly, just the structure of the bill. I mean, I'm not quite sure why you need even Section B of the bill anymore if you've already narrowed the alleged provisions of what the court can issue an order. So there are a variety of different questions involved that I think we still have, and I'll be happy to continue to work with the author.
Thank you, Mr. Votto.
Good morning, Mr. Chair. Members, Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice. We are also opposed to the measure. It's currently drafted, and I think we've had a chance to look at the most recent proposed amendments. I think Mr. Abaco covered a lot of our concerns. I think the first of which is, you know, we really need to strike a balance. Well, on the one hand, we do want to protect individuals from the types of situations that were just discussed. We have to look at whether or not current law affords opportunities already. Are there civil injunctions that can be obtained? And if there are shortcomings to the civil process or injunctive process, then perhaps we can look into going this route. The concerns that we have is that you are, again, potentially putting a lifetime ban on individuals to discuss issues that can be completely unrelated to the underlying case. The proposed language does not restrict it to the underlying case, issues of the underlying case, or with any kind of criminal intent. So there could be discussions on other issues with folks that have bona fide relationships, and those could be prohibited by this bill. And again, there's a jurisdiction issue. The court does have jurisdiction over individuals who have a case before it. They don't really have jurisdiction over other individuals. I'm not sure if they plan on taking out that provision of the bill, but to enable a court to impose an order that is subject to criminal contempt on someone who was not party to a proceeding, who potentially has no notice that they're not allowed to have a discussion with certain individuals because they're friends or co-workers of people who are involved in a case, really turns the court system on its head. And that's why we have the civil process available. If there's a specific threat, specific concern, specific act of harassment that is presented, then you can go out and in a variety of ways get either restraining order, get civil injunction, civil proceedings. Those are all available. And so we take a lot of pause on creating a new criminal contempt that could be lifetime and probably beyond the jurisdiction of the court. So I have other concerns, and I'm available for questions.
Thank you, Mr. Hernandez. Before we move forward, we are going to establish our quorum.
Leno?
Here.
Cogdill? Here. Cedillo? Hancock? Huff? Here. Steinberg? Wright? Here.
We have our quorum. Thank you. So I think we're going to have a number of things to talk about, and Senator, certainly you're welcome to make any response that you would, and Ms. Allred will take your legal counsel under advisement as well. So let's start at the top with regard to the jurisdiction. How would you, or as author, Senator Flores, respond to the concern that once a trial is over, that there is no jurisdiction for these parties.
Well, I think I might answer it the opposite way. Once a trial is concluded, there doesn't seem to be a remedy for a victim who is constantly harassed. So we are trying to find the balance here.
That's right.
I think the reason that we took this bill on is because in many cases the courts wipe their hands of an issue once in their mind a case is closed, and this is where the loophole for victims is very pronounced, where somehow after that fact there's no way for attorneys to come in and say, however, there are some extenuating circumstances here, and I don't know if Ms. Allred wanted to add some practicalities to it, but as someone who is practicing every day, this is kind of the thing that we're trying to solve.
Right?
Yeah.
Ms. Allred?
Yeah, obviously the criminal court does have jurisdiction after conviction and prior to sentencing. There's no question about that. And so the court could make orders at that time in reference to the defendant and or his or her agents, anyone acting on their behalf. And so, yes, I think the idea that we just refer all this to the civil courts is not actually viable for most child victims who are not going to be able to find an attorney to work pro bono or not be able to afford an attorney. So we're looking to try to find a way to close that loophole so that, I mean, the court had a reason to protect the name of the minor in the first place. And so we're trying to find a way to continue to protect that minor's privacy.
And if you could just help me as a non-attorney, for someone who is not a party to the proceeding and is potentially acting on behalf of the assailant, possibly not, are there not other laws in place that would protect the defendant or a potential future victim, any kind of protection from harassment or the kind of experience that Ms. Albon had to endure?
I did not find any, and if the criminal defense attorneys would like to cite which laws they think already adequately address the situation, I'd be happy to review it. I don't think there are any that adequately or, in fact, at all address the situation. This is not a, threat of violence, for example. This is what I described. And so I don't think it would fall under the purview, and I don't think she enjoys the protection of certain laws to seek an injunction against this. In any event, if she did, well, I mean, the damage has already been done. We're trying to avoid the damage
Correct.
in the first place by the courts issuing an order, and also the rights of the defendant are protected because upon good cause, a noticed hearing could be requested before the criminal court, and he could show or she could show why such an order should not be issued, which I think should satisfy the due process rights of the defendant abundantly.
Okay. And then secondly, there was concern about the overreach that maybe the bill should exempt appellate or habeas counsel. Mm-hmm. So if there are cases going further, that we wouldn't want to prohibit the defendant from having any kind of legal counsel, accessing information that
I would have no problem with that. I don't have any reason to think that counsel would act in an inappropriate
So that
manner.
was not the intent?
No,
That
not
isn't
as
the
to legal counsel, certainly not.
And then, this hadn't been raised in testimony, but it is mentioned in our analysis. Should this be with regard to an application to any case where the victim is a minor? For example, if the victim, the crime against the victim was petty theft. That's a different situation, or not?
Well, we can work with your staff to figure out what ultimately is the bar for that, but I think we're clearly talking about, petty theft probably isn't in our mind when we think of these types of issues. So there seems to be some thought process that this would be for these types of crimes we've just mentioned.
So we want
today.
to put that into the bill?
Would be up to you, Mr.
Sure.
Chairman.
But again, that's not your intent to be that overly broad anyway?
No.
Okay. Senator Wright, you had a comment or question?
The concern I have, and certainly the ordeal that the victim went through is concerning, but let's assume, for the sake of discussion, that the communication from the investigator was accurate. So let's assume that the witness, or in this case the victim, had lied, and that those claims that were being made were not based on a conviction of several circumstances, but it was only one. And let's say that it wasn't a life sentence, but it was 5 years. And the conviction was obtained on information that was fraudulent. Does the defendant have the right to pursue an investigation to seek information that might exonerate him, or is he forbidden from being able to defend himself because his accuser is a minor?
Again, the bill, and I think that's a fair question, but the bill does provide for the defendant, through his representatives, through his attorneys, to ask the court not to issue the requested order. And he can present whatever concerns he has and reasons he has at that time to the court, and the court can make an exemption.
I think there's still a due process issue that is allowed the person that you've just mentioned.
Okay, if I could, through the chair, I was going to hear from the other. I didn't want to do that, but he had an answer as well, the other side.
Mr. Blanco?
Just as I understand the bill, if it comes to committee, the order that's initially going to be issued, that the court is authorized to issue in cases of sexual crimes against a minor. So I think that issue was taken care of by the author. That may be a little too broad as it is, but just leave that as it is. The order that's supposed to be issued by the court is an order prohibiting the defendant or somebody acting on behalf of the defendant from annoying, harassing, intimidating, or threatening an appropriate person. So this due process good cause issue is sort of irrelevant, because the way the bill was originally structured, it prohibited anybody from even talking to anybody. So then then that's why they put in the good cause provision to go back into court. It says, yeah, I can talk to somebody, but you can talk to somebody, but you can't talk to somebody and prohibit, annoy, harass. So, I mean, they've narrowed it. You've narrowed it on the get-go.
Mr. LeBach, just to clarify for the committee, we have no amendments before us, so we don't have them. I don't have them. So if you could just speak as the bill is written. These are proposed at this point, but we don't have any amendments.
I apologize.
That's
I was
okay.
speaking as to the bills. I thought it was going to be changed.
Right.
I mean, as the bills came to committee, I thought it was a prior restraint on speech. I thought it was unconstitutional on its face. As it's proposed to be changed, it certainly narrows the legislation, and you just have to make sure that you take appropriate exceptions to permit defense attorneys and their counsel and their investigators to do their job.
And that's what the bill does now. It allows a due process for someone, I think, as Ms. Howard mentioned, who feels that they, in essence, need to go further in their investigation. It allows them that recourse, and so I think it does exactly as it's been mentioned.
And Senator Cogdell will come back to Senator Wright.
Thank you very much. Just for clarification, I guess, on my part, it sounds to me like what you're really asking for is to give the judge an option to rule on a motion brought by the victim's attorney,
right,
as a result of a situation that's either developed or there's an awful good chance that it will develop. And based on the presentations of the victim's attorney and the defendant's attorney at that point, the judge with this law would have the option to do what you're seeking as it relates to protecting the victim. Is it just that simple?
That's about as simple as I could put it, Senator Cogdell.
So it seems to me, again, from the due process standpoint, all we're doing is allowing a judge to
make a decision,
hear the merits of the motion, and make a decision based on that. Right now, they don't have that option available to them, and as a result, the victims are exposed to who knows what kind of harassment in this day and age with the technical realities that exist. So to me, it seems to me to be a good bill, common sense, something we should have probably been doing a long time ago.
Thank you, Senator. Senator Wright, you had another comment?
The concern I have is, it's one thing if it's like paparazzi. So if the guy from TMZ was showing up at a victim's home, and if we could specify the kind of contact, that would bother me far less than if the person who is being charged or who has been convicted ends up having to have another effort in order to defend himself. I mean, there are, I can probably think of 50 cases off the top of my head where there were defendants in sexual cases where the victim lied. And in some instances, people went to jail for a long time. And the reasons vary depending upon the person who committed the crime. On the other hand, there are far more instances where the victim was accurate and they were sexually assaulted or, in some cases, murdered or other things. The amendments make me a little bit more comfortable. I can't support the bill in its current form. We're not considering the amendments today, so today I'm simply not there because absent the amendments that assure that a person does have a right to defend himself, which I'm not sure are clear in the bill as before us. I might be far more comfortable with the amended version, but I haven't yet seen the amendment.
May I just respond for a moment, which is to say that, thank you, Senator Wright, for those observations. It's my experience as a victims' rights attorney, too, that there are many child victims who are afraid to testify for fear that, A, their identity will be known, B, that they will be harassed. It's also been my experience that that often victims who are harassed by the perpetrators of the crimes against them, the sex crimes against them, are far more traumatized by that than, frankly, than by any press that comes to interview them, whether it's TMZ or anyone else. So it's the idea that the connection with the defendant, the criminal, the perpetrator of the crime continues through after conviction when they thought it was going to be over at that point. So, thank you.
Mr. Chair, could I...
One last comment, and then we're going to conclude.
Very briefly, and I apologize, because I think that I had a little bit of confusion of whether we were talking about the bill as proposed, as some amendments that the author's office has been very open in sharing. So let me just clarify. On the due process question, what we haven't talked about is the due process rights of third parties who are not affiliated with the case whatsoever. We've talked about the defendant, but the way the bill is drafted, if my relatives or involved in some case in the situation, I would be subject to criminal contempt for having conversations with the victim, who may be my cousin, victim's family, co-workers, so on and so forth, as the bill is currently drafted. There's no due process. I would have no notice that I am subject to criminal contempt. There's no way for me to be part of that discussion from court because I'm not subject to the prosecution. So that's one. Number two, the judge does currently have authority to place conditions of probation and parole on an individual after sentencing, saying that you have to stay away, you cannot annoy, you cannot harass, you cannot contact. So that can be done. This goes further because this would go beyond the terms of probation and parole, and when that's over, they would give court jurisdiction beyond that. And the last thing is that there are statutes on the books regarding harassment and intimidation. I mean, those can be prosecuted. The question is whether a conversation that's annoying, crosses that threshold or not, and that's our concern as well, as having, again, criminal contempt hanging over someone's head for a conversation that is annoying, unrelated to an underlying charge of a third party who has no notice of criminal contempt. So I think those are issues that we've raised with the author's office. I know that they're looking at addressing those, but the bill as it stands now has those defects.
Very good. Thank you, Mr. Hernandez. So, Senator, not unlike the situation with Senator Ashburn, there's not a second policy committee, so we're not under the gun relative to schedules and deadlines. So to make sure that we get this all right, because there are about 3, at least maybe 4 different components that we need to review, and you've already agreed that some of these things were not the intent of the bill. And since the page of amendments floating around is a work in progress itself, how about if we take the next week or so, no later than to have in print, and so we could vote on them here in committee on the 20th. Because I want to support the bill, and I want to see Ms. Albin get some justice out of this.
Okay. Let me just say a couple of things. First, absolutely, you're the chair, Mr. Leno, but I think the intent of the bill has been, at least the amendments have been shared. This bill has been narrowed substantially. I mean, absolutely substantially. I think the only place to go in this discussion then, in the meantime, is to go up. In other words, I don't feel we can narrow it any more than it has. I think we'd be making an argument to open this up for judicial discretion as much as possible. Judges make good decisions. I mean, judges can make a lot of decisions, as been mentioned earlier, but if they don't have the option to even make a choice, I think, as Senator Cogdill mentioned, that makes it very difficult in the first place. The genesis of the bill was because there was no recourse for Ms. Allred to, in essence, point to something in statute that allowed a judge to make a decision on a third party. And it isn't the cousin. And the cousin is absolutely welcome to come in. This is an agent of someone who was put away, who, bottom line, went out to harass and intimidate. The goal of this bill, quite frankly, is to simply close that loophole, and it is a very big loophole for many of the victims, particularly those who aren't going to be able to afford, even on a pro bono basis, or even get the attention of attorneys. I think this is the purpose for Ms. Allred being here, is so for those victims far after this bill is passed and hopefully signed by the governor. So I would simply say we would love to work with you, Mr. Wright and others who left. Their staffs have the amendments. They are broadly shared. We shared them with the opposition. Obviously, they were going off of those. So I would just simply say that if we are going to put it off, let's really, in essence, try to close this. And I would ask that we work with Ms. Allred's office to make sure that it is an appropriate remedy, because it doesn't do us any good to stall this for, or at least to ponder this, for the next week or so, only to have something that is not going to be of real use to attorneys in court on a real-time basis. And,
sure. And let me just clarify for you and for Ms. Allred and for Ms. Alban that I am with you 100% in why you're here today and what you're trying to do. But clearly through this conversation, we've realized that there are some potential unintended consequences and potential even constitutional questions. So we want to, whatever we deliver, to be able to stand any kind of constitutional questioning. And relative to an earlier conversation we had together prior to the hearing, right, I also want to make this final product something that's agreeable for you as you move forward through the rest of the process. Right. And Senator Cogdill.
Thank you again. Just for clarification, are we talking about when the victim's attorney would bring the action before a judge, there would be specific individuals named in that motion, correctly? Or correct? Yes. I mean, you're not asking for a class of people to be right. Off limits here.
These
you're
are
saying this individual,
people. Right.
that individual, for specific reasons that a judge will weigh the evidence and make a decision as it relates to those folks, and they'll be obviously notified of that.
Yes.
So this third party that could be breaking the law somehow unknowingly, it's a moot point, isn't it? Is it?
Yes, it would be specified person, Senator. You're absolutely right. And she wouldn't even have to have a civil attorney. She could have the prosecutor, the district attorney, who is handling the criminal case on behalf of the people of the state of California, could make that request of the court.
Okay. Thank you.
Okay. Thanks.
So again, just to conclude, we'll work together. I think there's no question among committee members that we want to craft something that will ensure that that which Ms. Alban has had to suffer will not be repeated, and there will not be further incidences of this, and at the same time make sure that it is constitutionally sound.
Okay.
Thank you very much.
Thank you, Mr.
Thank you, Ms. Allred. Ms. Alban, thank you very much.
Thank you.
And we'll be working together. Thank you. We will next take up our item number 4, which is authored by Senator Oropeza, her SB 1066, and then we'll follow that with SB 1067, our item number 5. Welcome, Senator Oropeza.
Thank you so very much, Mr. Chair and members. May I proceed?
Yes.
Thank you. This measure requires the Department of Corrections and Rehabilitation to conduct random searches of all employees and vendors entering a prison. The bill would also require the Office of Inspector General to oversee these searches and to ensure the integrity of the searches and of the process. Finally, the bill would require a report be generated to the legislature detailing what the findings are of these searches. As a recent March 31st Sacramento Bee story explains, bringing in contraband can be a very lucrative endeavor. One employee was paid $1,500 by an inmate to bring in a cell phone. The number of cell phones confiscated in prison in 2006 was 261. Last year, it was 6,995 cell phones. That constitutes an increase of 2,580%, colleagues. And not to make light of this issue, the Office of Inspector General found in a report of May 2009 that, quote, inmates' access to cell phone technology facilitates their ability to communicate amongst themselves and their associates outside prison, to plan prison assaults, plot prison escapes, orchestrate a myriad of illegal activities. In addition, these devices can provide an inmate unrestricted and unmonitored access to the Internet, whereby they can communicate with unsuspecting victims, including minors. We have a representative from the Inspector General's office present to answer any technical questions the committee may have, and I would respectfully ask for your aye vote.
Thank you, Senator Oropeza. I know that you've been following this issue for some time. So, in fact, what the bill attempts to do is to codify an already successful practice of Operation Disconnect.
Yes, sir, that's correct.
And then to include the Inspector General to oversee the searches.
Yes, that's correct.
Very good. So, witnesses in support.
Thank you. Excuse me. Thank you, Chairman Leno and members of the committee. Jim Lindberg with the Friends Committee on Legislation of California. To our knowledge, there's never been an instance where a visitor has successfully, or a documented instance of where a visitor has successfully smuggled a cell phone into a California state prison. We believe that this is because of the effective screening that takes place, where visitors are required to walk through metal detectors that are so sensitive that women cannot wear underwire bras. We think that in the interest of safety in prisons and on public safety, that anybody who enters a prison should be subjected to some form of screening. We understand that the cost of metal detectors right now is prohibitive, but we think that this is a step in the right direction. Thank you.
Thank you. Others in support?
Thank you, Mr. Chairman and Senators. My name is Vanessa Nelson, speaking on behalf of Life Support Alliance. We are an organization of friends and families of life-term inmates. You should have before you a letter of support from our organization detailing our reasons for support of this bill. I would just like to reiterate a couple of points briefly. Our members visit prisons every weekend. I spent this past Saturday and Sunday visiting at Avenel State Prison. Senators, this is my prison purse. This is what we are allowed to take in. The items that we take in to visit are contained in clear plastic containers very much this size. The few items that we are allowed to take in, which is a specified amount of money for vending machines, our identification, our car keys, and a few pictures, are always searched. Even these transparent containers are searched. The clothing that we wear in, including the color, is restricted by the department. The amount of jewelry that we can wear in is regulated and always noted on our visiting passes. While all this property is being searched, we are busy turning our pockets inside out, lifting our pant legs to show we have nothing on our ankles, and in the case of some visitors with long hair, lifting their hair to have their necks inspected. Then we are sent through the metal detectors that do indeed detect underwires and bras. While going through this process this weekend, I had the opportunity to again watch the parade of staff members coming on for their work shifts. Almost without exception, they came with baggage. Large coolers on shoulder straps, backpacks, duffel bags, tote bags, sometimes a backpack and a cooler. None of this was inspected, even in the most cursory manner. Staff has simply waved through the gates and the sally ports with no inspection and no metal detection. In another life, I've spent 20 years as a retail manager for some of the nation's largest firms, and their practice in these firms is always to have people leaving the stores inspected, their backpacks, their books, their purses. This is an effort to keep things from going out. In this situation, we're concerned with items coming into the institution, and it strikes us as simply sensible that the accoutrements of everyone entering a prison should be at least looked at. The Department of Corrections is rightly concerned with the safety and the security of the institutions, and so are the families and the friends of inmates. We believe it makes good sense to investigate all the avenues that contraband can be introduced into the prison, and right now one of those avenues is wholly unregulated. We believe SB 1066 is a good step, a first step, in the right direction, and we urge its passage.
Thank you for your testimony and also for the good work that you do on a regular basis.
Thank you, Senator and Mr. Chair and members. Matt Gray on behalf of taxpayers for improving public safety. Without repeating anything that was already covered, we thank the Senator Oropesa for taking the amendments to include vendors and changing the bill to do a spot check instead of every single staff member. That would undoubtedly interfere with prison programming and other valuable resources. And so with those amendments, we are pleased to offer our support. Thank you.
Thank you, Mr. Gray. Anyone else in support of Senator Oropesa's SB 1066? Anyone here to speak in opposition? I don't know that we have any. Well, maybe we do.
We do. Late opposition from CCPOA.
Welcome, gentlemen.
Craig Brown for the California Correctional Peace Officers Association. We support the goal of the bill of eliminating contraband. We have three specific issues with it. One is we think the bill limits it to employees and vendors. We think it should be everybody. If you step foot on the grounds, again, our issue isn't with visitors, but it's with everybody else who comes on the prison grounds. That if everybody's going to go, if our goal is really zero tolerance for cell phones, it should apply to everybody who shows up. We should, and again, our issue isn't with visitors, it's with all the other official visitors who show up at a place. Secondly, and more importantly,
when you
if you show up.
No, that would be Senator Huff.
Or Senator Huff. I did get inspected when I went through. Thank you.
Very good.
Okay. That's our minor issue.
So it's just official visitors, because everybody else, visitors.
Again, our issue is not with the visitors who are subject to.
And staff.
Yeah.
So out of the universe of the world, all those excluded at this point would just be what you've called official visitors.
Would be people who are showing up other than visitors to see inmates.
Okay.
We don't have a problem with it covering inmates, but that's not our issue. Our issue is with everybody else who shows up.
Go ahead.
Including management. The prison
Got your
system.
point. Go ahead.
Secondly, our issue is this bill needs to incorporate a mechanism for staff to be able to deal with the family emergencies and notify their family on overtime. Our members, as you well know, are often ordered to work overtime. So you go to work at 6 in the morning, leave your children at home to take themselves to school. They expect you home at 2:15 because you got off at 2. And they come home from school, open the door, and nobody's there, and you can't call them. The management of this department does not allow staff who are ordered to work overtime to use a state phone to call and notify their family. This bill needs to incorporate a provision that says when your working conditions change at the management's discretion, you're going to at least be allowed to call home and tell people that you're at home. Thirdly, these searches, which are in place, back up the gates. So again, if you're working 6 to 2 in the morning and I'm your relief and I'm stuck in line waiting to be searched, you're held over. You're not compensated for that overtime. That overtime can be significant. It is compensable, and the bill needs to carry in a mechanism to ensure that those costs are covered. Those are issues with the bill. Again, it's not with the goal. It's with the details.
And given that this is just codifying the ongoing practice, are you experiencing those problems currently?
Yes, we are experiencing the problem with the overtime. Frankly, our members, we suspect many of them bring a cell phone in so that when they're ordered over, they can make a phone call to tell their family. Again, do you want children coming home to an empty house expecting their loved one to be there, and they aren't available because they've been ordered over, and you can't even call and leave a message on the answering machine? Hi, the department's ordered me to work, and I'll see you at 10:30 tonight instead of 2:30 this afternoon. That is an important issue, and we suspect some of our members actually bring the cell phones in, a personal cell phone, in to deal with that. That's why we've dealt with, we've supported legislation that your committee's passed involving intent to give the inmates and all that. We've supported those bills because we want to stop the contraband, but our members need to be able to communicate with their families.
We hear you. Okay. Other opposition?
Mr. Chairman, members, Paul Curry on behalf of the Correctional Supervisors Organization. We also oppose the bill.
Sorry, what is the name?
Correctional Supervisors, your office received a letter. Correctional Supervisors Organization. we have similar concerns. One of our main concerns that we'd like to articulate is also not just the fact that they get pushed over to work overtime because we're such short-handed. The other issue is that you have folks who are with their wives when they're pregnant. There's the need to get a hold of the individual so that he can leave to attend to his family. That gets removed. We also understand that that's a policy issue that needs to be addressed within the department. We further understand that the department is taking the necessary steps, and to codify at this point, before they've really had an opportunity to work through this process, is maybe taking it or building the box a little too tight because they may want to change the current program to address this. One of the issues, and you have to look at it, if you look at this building, for example, and I hear people refer to it as how we have to go through the metal detectors. We all know that not everybody goes through the metal detectors. If you enter this building through certain portals, you don't go through metal detectors. The people who are working in these positions are subject to background investigations, and quite frequently, you know, we in management on our side of the aisle, with working in the prison system, work diligently to identify and seek out the individuals who may or may not be suspect, and we check those folks out. And with our spot checks we're doing now, it's working. But to have to bring in the Office of Inspector General to stand over top of our shoulders to do that, we think it's wasting time. We also are very concerned about the fact that we're trying to do more with less, and this is going to cost us more money. So we offer you that as our opposition.
Mr. Chair, this is totally new information to me. We did receive a letter which indicated, and I'll read from the letter from this organization, if this bill cited that the Office of Inspector General would oversee these searches but would not conduct the searches themselves, the CCSO would have no objection to this bill. We took that amendment, sir. So I'm willing to talk with this gentleman, but it's new information.
Very good. Thank you. It's also new information to the chair and to the committee. We have no letters of opposition on file whatsoever. Senator Wright.
I guess officers who work at the institution typically have lockers. Would that be?
No. Is Mr. Brown still here? Maybe
From CCP.
you could respond to Senator Wright's questions. Mr. Brown?
Everybody sit down so you're on the mic.
Oh, I'm sorry.
If you want to answer a question.
Most facilities, they do not have lockers.
Okay, so
the lockers are car in the parking lot.
Okay, and the reason that I raised that is, and I've been to a number of institutions, but I've not been to them all. But if the officer simply left his cell phone in the car, or if he took advantage of a landline in an office to make the phone call that you're describing. So I'm just saying, so let's say he was working cell block C, and he was given overtime. There'd be a way that was communicated to him. Someone probably would have come to cell block C and said, Craig, I need you to work overtime. Why wouldn't he simply go to, if he didn't have a locker, to the office and make the phone call that you described?
Management doesn't permit it.
Okay, so
you're on post, you're there. They basically take the attitude they didn't issue a family, it's not their problem.
Well, but let's suppose that same officer had to go relieve himself and he needed 5 minutes. There's a provision that would be made for him to do that, right?
There are provisions, and for instance, the control rooms have a restroom. They have a phone, but management won't let you pick up that phone and give you an outside line. So if you're the control room officer overseeing a housing unit, you can relieve yourself. There is a restroom in the control room. You can have your lunch, as the witness pointed out. You can bring your lunch in. You cannot pick up the state phone and say, I need to call home. Could you please give me an outside line? The answer will be no.
Okay, so the solution to the problem that you describe isn't that we let him carry the phone, it's that we grant him access to an outside line.
Correct. That would solve the problem as long as it was both ways, so emergencies could call in, true emergencies, and the officer could notify going out. That would solve that issue. That's correct.
I'm sorry, Mr. Chicken.
Go ahead.
What's the current practice if an emergency was from the outside? What happens now?
We believe most of our members probably get a cell phone call.
So currently,
So the members are currently violating the law.
They have no opportunity if they want to stand. It's not the law. It's a department rule. And they get disciplined for it if they get caught. But they simply have a choice. Violate that rule or not stay in contact with their family. It's not a particularly attractive choice.
But as I look at Senator Oropeza's bill, and I'm concerned, is we have instances where someone with a cell phone orders a hit in Compton from a secure facility in state custody. And if I'm able to determine that that phone was given to them by a guard, that would be of a concern to me. I would be concerned about making sure that the guard have adequate means of communicating both in and outside. And if that's simply a matter of by policy or by statute saying that an officer, upon being given overtime, has a right to a telephone call outside, then that might be the solution to what you described.
That's our issue. That would solve our problem. Again, as long as a provision is made so they can call out and let their family know that they're not.
Okay, I mean, I don't have an
Senator
amendment.
Wright, I think we're into management labor negotiations right now.
Okay.
I don't know that's really the purview of the committee. It's a good conversation, but I don't know that this is going to impact the bill. But thank you, Mr. Brown.
Okay.
Senator Cogdell.
Thank you. I just had a quick question on the current procedure. If management asks a guard to work overtime, they don't have a procedure where they can pick up the phone or have someone pick up the phone and call that guard's family to say your loved one has been requested to work overtime?
That's correct. The correctional officer is left hanging, and his family is left hanging. As you know, if it's not a particularly safe environment, bad things happen in prison, so you get to worry for 8 hours if you're the family. That's why we suspect that many of our members solve that problem by bringing a cell phone for personal use. They don't redistribute it to inmates. We're not suggesting that's the only mechanism. If the bill wants to provide a mechanism that says an officer has the right to make a phone call in order to work overtime, and the management will have a provision to notify officers when there's a true family emergency, that solves that issue. But that's not in the bill, and that's not in the practice.
Senator, Mr. Brown, at great risk of extending this conversation any further, I just wanted to ask, what was the situation with regard to this issue prior to the advent of cell phones in everybody's hands 15 years ago?
I'm old. I'm not that old.
15 years ago?
15 years ago, people had cell phones.
I don't know.
But
so 15 prior to the proliferation of cell phones?
I don't know. I think that my guess is that labor relations were a lot different back then, and the prisons were a lot smaller operations, and they probably let people make phone calls. But I don't know that for a fact.
Very good. Thank you. Anybody else wish to speak in opposition to the bill? And again, I'm sorry that neither of the opposition voices today had communicated with our staff in any way. We have a letter?
Late opposition, yeah.
Got it.
We got one late.
All right. Very good. Late opposition from CCPOA. Any other questions from the committee? Senator Huff.
I did get a letter from CCPOA and indicated it was sent to the committee, although our staff didn't get it. I have some concerns about that. I don't know if it's something we can, I don't know if that violates management and labor contract, but it seems like if you're precluding them from carrying it or tightening it up, there should be some way for them to communicate with the family.
Yeah, I agree. We're going to continue to, as I said, this was a late development. I'm absolutely willing to sit and talk with them and try and come up with a way that is within the parameters that we have to try and address their concern.
Okay.
I'm willing to do that.
I mean, I'm willing to support this if we take care of that concern,
Yeah,
but that
I
seems
hear you.
unreasonable. If I was a family member and, you know, my spouse
I can appreciate their concern.
Yeah, exactly. All right, thanks.
I think the points are well taken, Senator Cogdell.
Thank you. And as it relates to the other issue that was raised concerning, expanding this to everybody, if the goal is really to stop, to have a zero tolerance on contraband, then shouldn't we look at maybe expanding that? That seemed to make a lot of sense to me. I don't know if it's something you really had thought of before.
I thought we had, frankly.
Okay. All right.
So, I mean, with the exception of elected officials, which I guess aren't vendors, but I consider them visitors. I don't know. Those who have visited prisons have experienced the visitor treatment, but apparently in some cases they may not. I don't know. Again, it's a new issue, but I will certainly, take a serious look at that.
So just to clarify, the committee, you would like to see everyone who enters
Absolutely. I have no objection to any
be subject
class
to the random
of individual being
Well,
exempt.
I think that's where I am today. I'm willing to support the bill to
Thank you.
keep it moving, but I have the same concerns as Senator Huff raised. Seems to me there's got to be a way to work that out, and also to make sure that it's as comprehensive as it needs to be. So
I totally
again,
agree with you on that second
I'm willing to
point.
move it, and I'll look
Absolutely.
at the amendments and hopefully be able to support it all the way through.
So I will take that as a motion by Senator Cogdill. Thank you. So just to reiterate what I believe is the desire of the committee is that in supporting your bill today, that we are mindful of the late voices that came to speak and describe the situation that we could inadvertently put our prison guards in as a result of the bill itself, and then additionally that your original intent was that every individual, without exception, who enters our prison systems would be subject to this Operation Disconnect.
Well, that they would in some way be searched. Let me say that this program that we're talking about today is the surprise searches of paid employees, and it certainly was our intent that include all paid employees, and that every visitor be treated the same way. Absolutely the case.
Very good. So we will call the roll.
Leno?
Aye.
Leno, aye. Cogdill?
Aye.
Cogdill, aye. Cedillo? Hancock? Huff?
Aye.
Huff, aye. Steinberg? Wright?
So we have 3 votes with 3 members of the committee here. There are other committee members who will be returning before we conclude today's work, so we'll put that on call. And we'll move on to your second bill today, which is SB 1067, our item number 5.
Thank you very much, Mr. Chair and members. This is a very simple bill with a simple goal. The bottom line is that we need to track state juvenile wards in their detention centers and when and who they are when they return and for what reason they return. It's amazing to me that does not currently take place, but indeed that is, to my mind, something that I actually learned in my experience in interviewing individuals who came before the Rules Committee for appointment to corrections positions. It also puts in statute the term that everyone uses, the term of art that everyone uses, which is Department of Juvenile Justice, instead of the more formal Department of Juvenile Facilities, a fairly technical measure. Last year, as I mentioned during the Rules Committee, it became clear that the Department of Juvenile Facilities, as it is currently called, never really tracked the recidivism rates with an average cost per year per ward of $250,000 and an objective of rehabilitating young people so that they do not return to the system. I found this absolutely appalling, this fact appalling. Without benchmarks to gauge success, we have no way to determine which programs are working, which are not, determine accountability, and how best to spend taxpayer dollars within the Department of Juvenile Justice. So I am respectfully asking your support on this important measure.
Very good. Thank you, Senator. Those in support?
Mr. Chair, members of the committee, my name is Jim Frayne. I represent the Deputy Sheriff's Association of Orange County, Sacramento, the California Coalition of Probation Organizations, Anaheim Police. This bill is extremely important. You senators will recall that it was only a few years ago that we changed the name of the Department of Corrections and added rehabilitation. Presently, as I speak, they're proposing in the budget to cut $250 million from rehabilitation from our Department of Corrections. And I don't think I have to reiterate that juveniles that are in state prison are redeemable. Mr. Cate, who's the Deputy Director of the Department of Corrections, has said that cut will not affect them because they're going to focus in on programs that really help education and rehabilitation. Whether that's possible, I don't know.
but this bill is extremely important. How can you gauge with that kind of a cut to rehabilitation, and with releasing these other prisoners into local communities with no oversight of parole and a shortage of police officers? Even more, we need to know recidivism in California for adults is 70%. It's a lot less for juveniles, but without a gauge, and this mandates that, and it's only for juvenile, we urge an aye vote. Thank you very much for carrying this bill.
Thank you, Mr. Frey.
Craig Brown for CCPOA in support of the bill. We'd hope the rest of the country would adopt something similar, very clear definition of what recidivism is, and track it so when people fly around numbers about this is better than that, they at least have a common basis, which we don't have now. This bill is a good start. We support it.
Thank you, Mr. Brown.
Hi, my name is Pam Handel, and I'm a teacher in DJJ, and I've been here before. SEIU is in support of this bill, and as a teacher, I am totally in support of this bill. I would like very much for you to consider looking at things like, did education and treatment contribute in the success of the parolee? I think that would be very helpful in the 4-year study. It looks like it's a 4-year study. And I think that that would be helpful in funding in the future for those programs if they are successful. We find that often our students will call back and they will say that the vocational trades that they learned that got them the job, or their diploma or their GED, is the reason why that they are successful. So I think that this is wonderful, and it would be a great way to find that out. Thank you.
Thank you, Ms. Handel. Others in support? Any opposition? Very good. I just want to direct the committee's attention to the proposed amendments on page 9, which you
We
are
really appreciate the help on those amendments. They're
accepting as
great
authors amendments then.
Absolutely.
Very good. So I know that you've looked at the success in Washington State and want to duplicate that here. And again, I followed your line of questioning in any number of Rules Committee hearings and appreciate your support in an issue that we've been dealing with here in this committee for many years. I was rather surprised to see that the recidivism rate is defined by reincarceration within 2 years is at 50%, but if you extend it to 3 years, it's above 3/4, 75%, which really is a clear indication of our failure and our statutory responsibility to provide education to our DJJ guests. Any other questions from the committee? We have the bill as amended. Moved by Senator Cogdill. And if you'd like to make a brief close, Senator.
I just would respectfully ask for your aye vote on this measure.
Thank you. We will call the roll.
Leno?
Aye.
Leno, aye. Cogdill?
Aye.
Cogdill, aye. Cedillo? Hancock? Huff?
Aye.
Huff, aye. Steinberg? Wright?
Aye.
Wright, aye.
Bill is out. We'll leave it on call for other members who will be returning.
Thank you very much, members.
Thank you,
and Mr.
Senator
Chair.
Oropeza.
Thank you.
Our next item is number 6, Senator Denham's SB 1078. Welcome, Senator.
Thank you and good morning. It's good to be up here while this committee's moving so many bills out of here.
Go for it.
Mr. Chairman, members of the committee, California has found a new trick to free up bed space. It's called transferring cop killers out of our state prisons to other states or countries where they will be released early and quickly. Annika Diesi, a Swedish national, pled guilty and was convicted of cold-blooded murder of Lake County Sheriff's Deputy Richard Helbush and in the killing of Stockton restaurant owner Joe Torre. Diesi was sentenced to life in prison and has been denied parole repeatedly by the Border Parole hearings. State and federal governments have transferred Annika Diesi to Swedish prison system, knowing full well that she would get released once there. This scheme was an insult to the victims' families and to our system of justice. A similar transfer scam was perpetrated involving SLA terrorist Sarah Jane Olson, who was convicted of trying to kill LA police officers and participating in the murder of Myrna Opsahl, a Carmichael church worker and mother of 4. My bill would do 3 simple things. First of all, it would require the governor to be open and honest if he or she wants a prisoner transferred and not hid behind the Department of Corrections. 2, it would require the receiving country or state sign an agreement that the prisoner will be held for the full term and not released early. And 3, prohibit any prisoner transfers if law enforcement officials where the crime was committed object to the transfer. I have witnesses here this morning.
Very good. Thank you, Senator. Those in support of the bill.
Mr. Chairman, members, Paul Curry on behalf of the Correctional Supervisors Organization. We strongly support this. We think this is a bill that really goes to the core of victims and providing victims the necessary, really, I'd say closure, but I think that's an overused word. I think it's just the ability to know that someone is paying the penalty that they've been sentenced to, and for this to be happening administratively and moving these folks out, I think it does deprive them of that some level of comfort there. And so our organization supports this measure and believes it's a fairness measure. And I think everybody should look at this in the light of day and make sure that what we're doing is, in fact, the correct move. Thank you.
Thank you, Mr. Curry. Others in support?
Christine Ward with Crime Victims Action Alliance. We also are concerned about the foreign transfer of prisoners. There was one particular case that we had worked with the victim on, the Pinto case, where this individual brutally murdered his 4-year-old. Just prior to being transferred out of the country, he was denied parole for 5 years. He was obviously serving life without or with possibility of parole, and then was transferred off to Portugal. The concern was after those 5 years, there's no telling whether or not that inmate will be released back into society into Portugal. And what type of treatment he would be getting in prison while in Portugal. There are some things that are missed, obviously, rehabilitation efforts, the opportunity for the victim to participate in the parole hearing process, and certainly the safety of individuals where this inmate is, where the inmate would be transferred. Those are our concerns with the foreign prisoner transfer, and we are in support of this. Thank you.
Thank you.
Thank you. Good morning. Dawn Kepke with McHugh & Associates on behalf of Crime Victims United of California in support for the reasons stated. Thank you.
Thank you, Ms. Kepke.
Craig Brown for CCPOA. We're in support, not because anything to do with the foreign transfers, but this bill seems to apply to also everybody transferred out of state. As you know, we've opposed the use of out-of-state beds that the legislature authorized till June of 2011. This bill, it seems, would help bring California jobs back to California. We see lots of signs around this building, California Jobs First, and the out-of-state program does nothing other than export jobs. California jobs supported by California taxpayers to other states. This bill would slow that process down, and we're in support.
Thank you, Mr. Brown.
John Lovell with the Police Chiefs Association. As stated earlier, this is, in our view, truly a victims bill. It's a very simple bill, but it, in some small way, deals with the feelings of helpless frustration that victims inevitably go through every day of their lives.
Thank you, Mr. Lovell. Anyone else in support of the bill? Those in opposition?
Good morning.
Good morning.
David Warren. Am I on? David Warren. Good morning. Taxpayers for Improving Public Safety. We're in opposition to this bill. The Department of Corrections in the state of California has more than adequate procedures to assure and resolve the issues that are suggested, i.e. not transferring inmates out of state. It has taken me 3 years, and Erev Pesach, I was finally able to complete the transfer of an Israeli national back to Israel after going through the hoops of getting the Board of Parole hearings to approve the transfer, the United States Department of Justice to approve the transfer, the Israeli Ministry of Justice, and the Israeli Bureau of Prisons. It is not a simple task. Simply put, the transfer of inmates out of this country is to the benefit of the state of California. It delivers them close to their families where they will have access to rehabilitative services. It will provide relief for the prison overcrowding, and it does not reward inmates for their criminal behavior. I believe this bill is short-sighted and should be rejected. Thank you.
Thank you, Mr. Warren.
Liberty Sanchez on behalf of the California Public Defenders Association. We're concerned about this bill and registered our opposition for a couple of reasons. The first of which, we're concerned that the attempt to maintain CDCR jurisdiction over prisoners released to other countries would basically ensure that other countries would be unwilling to accept those prisoners, and it would basically tie the hands of CDCR and the other countries unnecessarily. Additionally, we're concerned that one of the sentences in the bill seems to provide that prisoners may only be shipped out of state as long as it's ensured that their full sentence is served when out of state. And our concern is that it doesn't address the possibility of good time credits or credit for time served that would be afforded prisoners if they served their time in state. So for those reasons, we are opposed to this measure. Thank you.
Thank you, Ms. Sanchez.
Hi, Keith Chandler. I'm with the law firm of Sanders & Associates. We're active in prison reform and prison issues. I'm here today to oppose the bill for a couple reasons. First of all, and primarily, I'm not quite sure what problem we're here to address. We are talking about the transfer of a few, maybe a dozen or so a year, foreign nationals to other countries. But the bill's author has tried to place the amendment in the interstate compact section, which has nothing to do with out-of-country transfers. And I'm not quite sure why he's doing that, because Penal Code 11189, Article 4, Section B, states that inmates transferred under the Interstate Corrections Compact remain under the jurisdiction of the sending state. So there's no problem inside the United States with the 8,000 or so Department of Corrections initiated transfers. That's a ruse. And I'm not quite sure why we're trying to poison the Interstate Compact law with this by just bringing in like governor oversight or Roman Coliseum thumbs up, thumbs down to a transfer. It seems to me the bill's just designed to stop all transfers. The other problem I have is that we're talking about the inmate who'd been transferred to Sweden and some of the other rare instances where this may be occurring. The authors and the supporters of the bill claim that these inmates are sentenced to life in prison, and that's legally inaccurate. We have 4 punishments for murder in the state of California: death penalty, life without parole, 25 years to life, and 15 years to life. The individual at issue here, not trying to excuse in any way their crime or the pain that they caused to the victims, but they were sentenced to life with the possibility of parole, and according to the Department of Corrections' own statistics on their website, the average time served for first-degree murder is 26.3 years, and this individual has served that amount of time, and to my knowledge, she was not the actual killer. So I think that she would be favorably considered for parole very quickly in the state system if she was here, and it's disingenuous to call it an early release. I do want to say that I'm sure that there could be a problem in some of these foreign countries with this, but we could obviously address this without complicating the interstate compact. And in closing, I'd just like to add one thing. Anyone involved with the life prisoner parole process has to know how the governor's input and oversight has destroyed the entire workings of the parole board. To bring that mess into our prison transfer system is a very bad move, and I hope the committee can see that. Thank you.
Thank you, Mr. Chandler. If you could hang on, there may be some questions for you.
Thank you, Mr. Chair and members. Matt Gray on behalf of Victims Foundation. Not all victims want this legislation. There are a number of victims who want the politics and they want the politics out of the parole and transfer process. And as Mr. Chandler stated, bringing that highly politicized discussion into the transfer process is a profound mistake, and we ask for your opposition.
Thank you, Mr. Gray.
Jim Lindberg on behalf of the Friends Committee on Legislation of California. I just wanted to point out that California's Penal Code recognizes the importance of prisoners serving their sentences in prisons that are close to their families when possible. This assist in reentry. And we think that requiring the governor to sign off on all foreign transfers is to invite politics, emotion, impartiality, subjectivity into this process. We've seen how it works, as was mentioned, with the parole board, where people who have been denied repeatedly and finally get a date then have their release vetoed by the governor, we think on the basis of political reasons. We think that's bad for the cause of justice. Thank you.
Thank you, Mr. Lindberg. Anyone else who'd like to speak in opposition to this bill? Questions from the committee? I want to, I'm not
I
sure.
do agree with the final witness in opposition.
Thank you,
This
Senator.
it certainly is to interject politics and emotion into this. I think that's an important part of the governor, and the governor should be willing to sign off on these.
Mr. Chandor, or anybody else who's here, can speak to the prison transfer treaties to which the United States is signatory.
I can in the most general of terms. I know one I believe is the Strasbourg Treaty. In essence, David Warren had earlier explained very clearly, and I think David's come back up here. I'll let him take over on it.
I'm sorry, Mr. Leno. I wasn't aware that you'd be asking questions.
Sure.
There are essentially two compacts, the Vienna Compact and the Organization of American States Compact. They limit the countries to which people can be transferred. For example, Colombia is not a participant in the treaty. Many Eastern European countries are not parties to the treaty. The People's Republic of China is not. So there's very little chance that people will be transferred to countries of that type. More importantly, all the conventions require the voluntary request of the California inmate in order to make the transfer. There's no involuntary transfers. Does that address the issues?
That's helpful. Thank you. So this works both ways, correct? So if we were to break some of these treaties, which I think, and I'm happy to hear anybody else's response, this bill would do, then the United States is not going to be able to participate in any efforts to bring back Americans who are serving time abroad to complete their sentences here.
I can speak for 5 countries with whom I have been dealing, and their position would be that if California would not allow transfers there, they would not even consider transfers back to the United States.
And the bill states that any agreement to confine an inmate in an institution outside of the state must require that at all times the inmate shall be subject to the jurisdiction of the Department of Corrections and Rehabilitation, may be at any time removed therefrom for any purpose permitted by the law of the state. So, in effect, we'd be requiring that a sovereign country waive its territorial jurisdiction.
I can speak for 2 countries because I recently had a conversation with Foreign Minister Lieberman of the State of Israel, and I can assure you that that would not be something he would ever accept, nor would the prison authorities in the United Kingdom.
And then I also see that relative to the United States Department of Justice's guidelines for evaluating prisoner applications for transfer, that the United States will not approve a transfer unless the state first gives its consent.
That's already in the law.
That's right.
So that's not necessary. The
So
U.S. DOJ won't even process unless the Board of Parole hearings approves.
Right. And so that addresses some of my concerns. And then additionally, Senator Denham also wanted to make reference to an LAO recommendation of 2005, which recommended California increase its utilization of the foreign inmate transfer program. I wonder if you're familiar with that recommendation and have any thoughts on it.
It certainly would be a cost savings measure to transfer all of our inmates out of the state or out of the country. We could completely shut down our correctional system, but I don't think that would be in the best interest of our citizens here in this state.
I think that's a bit of hyperbole because the Board of Parole has successfully transferred 15 foreign inmates in the past 3 years. And in the federal system, there have been 857 transfers. So we're not talking about shipping 170,000,
Sure,
15 over 3 years.
I guess it just depends on your definition of a transfer that is good for public safety. These individuals have been released. I mean, they've been transferred, whether it's to a different country or to a different state. They know going in that if they can do this through the Department of Corrections or through the Obama administration, that they can do this knowing free well that they are going to be released.
And then with regard to your mention, you've brought 2 cases forward. One, Anika Deasy, who had served 25 years here in the state prison system before being returned for further incarceration in Sweden. The other was Sarah Jane Olson, which was a parole case. I don't know that there's anything to do with parole in your bill. Why is it that you brought her forward?
I think it's a similar scenario. We want to make sure that I think of the 3 issues that we're trying to resolve in this bill, the most important one is to have the governor sign off on it. Because like the final witness did say, that there obviously is politics and emotion that builds into this. We have a duty to the victims of this state first. And certainly, our law enforcement that so bravely put their lives on the line every day. And in both cases, law enforcement was attacked, killed, or injured.
And with regard to the treaties that we signed with other nations, you have no concern with those?
I absolutely have concerns with them, but we have a law of our state and of our country. And this is something where we are going around the Border Patrol hearings, that we are going around the district attorney and our own court system, and making an executive decision by our chief executor and by the federal government to usurp that. I mean, if you have pled guilty, if there is no doubt in the crime, and our courts have suggested that, why would you grant an early release to anybody?
Don't think that was the question I was asking. You expect, as your bill is written, that a sovereign country would waive its territorial jurisdictions because it would have to bend to the language in your bill that says that these inmates would be under the jurisdiction of California law, not their sovereign law. And those are the terms of the treaties that we have signed, and there are about 65 of them that would be put at risk.
I would expect that if they are willing to take a prisoner back, that they would abide by an agreement with our chief executive, yes.
You think they would?
Well,
right.
I guess, or they could lie to the governor, yes. Okay. But I think, again, the most important thing here is to have the governor, he or she, Republican, Democrat, sign off on every transfer.
Very good. And yes, Senator Cogdell.
Thank you very much. I think your bill definitely points to an issue that we're all concerned about as it relates to, number one, the budget problem that we're having in general, and the need to protect the citizens of the state of California to the best of our ability, and make sure that folks that are found guilty of crime in our judicial system pay the penalties that the people of the state expect them to pay. And I think that's something that's important, that we should be doing everything we can to guarantee that if we're going to transfer prisoners, especially from state to state. And I think that we have to make sure to the best of our ability that those agreements are in place. I have the same concerns about the treaties, and we've all talked about this over the years as it relates to the treaty, and it may be one of the ones that you mentioned with Mexico and the whole illegal immigration issue, and those folks that are in our jails, and what to do with them, and what happens if we send them back and they let them go and they're back within a matter of weeks or months in this country, carrying out their life of crime and impacting us all in a very negative way. So I think that's a question that's been there for a long time, and there's been a lot of concern about that particular treaty and whether or not it needs to be revisited. So I guess I have a bigger question as it relates to the legality of what we might do here, specifically relating to that issue. Do the treaties have precedent, or is it the ability of the state of California to write a law that would somehow supersede a treaty? I would doubt that we could do that. So anyway, I have that question, but I again appreciate what you're trying to accomplish with the bill, and I support it and will be willing to vote for it today, but I do think that's an issue that obviously has to be determined or resolved on those particular cases when we're going to another country versus a state within the United States.
Thank you, Senator Cogdell. Again, given that current law already states that the United States will not approve a transfer unless the state first gives its consent, that we are already in control of the situation. But to put into state law that we would have jurisdiction over these inmates when they are in foreign countries, when the treaties that we have signed state specifically, and the United States is a signatory to, that each party may grant pardon, amnesty, or commutation of sentences in accordance with the Constitution or other laws, that we sign into those agreements. Now, the state of California can disapprove of any transfer, so the United States government cannot consider it. So I think that we're entering into very dangerous waters here, and unnecessarily, because of the way federal law is already written. So for that reason, I won't be able to support the bill today.
And if it's the will of this chairman, I know that we have seen many amendments to many bills today. I would be willing to pare this bill down to simply ask for the governor to sign off on every early release, and that would take care of all of the issues as far as treaties with other nations. But I think very simply, it is up to our chief executive to decide whether or not we're going to transfer any prisoner to any state or any country, and it ultimately should be up to he or she to be held accountable.
Senator Wright.
Mr. Chair, and I think you stated it, in the last 5 years, how many inmates have we transferred?
In this state, 15, I believe, in the last 3 years. Transferred 15 foreign inmates.
So with a prison population at 170,000 over 3 years, we've transferred 15?
About 5 per year.
And most of those inmates, if I understand correctly, had served an amount of time that would have allowed them to be eligible for release here.
For parole?
For parole.
Probably. But denied. But denied by the parole.
But I just said eligible. I didn't say denied. But they would have been eligible for parole. See, I think, and how many of those have been granted by the Obama administration?
That I don't know. What the analysis says is that in the same 3-year period, the federal prison system had transferred 857.
No, just referring, I think I heard the senator reference the Obama administration and the wholesale transfer of inmates. I mean, the issue I have here becomes, and I'm not able to support as well, is we have a difference between revenge and public safety. And I think we often confuse the two. Revenge is expensive, and public safety we can possibly afford. And the more we go into revenge, we can say a lot of things. I'm not sure that the fact that we seek revenge makes anyone safer. And so I can't support it because this simply, in my view, goes back to revenge. We have a philosophical difference, although I appreciate you as a human being. But I just seen in this state the downsides of revenge. It doesn't provide more public safety. You end up spending resources and doing other things in ways that don't work toward making the public safer. So, you know, if someone has done most of their time, I mean, I think probably the laughing stock of California had to be that we took a comatose patient who'd committed murder and we sent her to a private hospital under the guise of public safety. And she spent 4 years at $700,000 a year with 3 guards watching her in a private hospital under the guise of public safety. And she went to a parole hearing and was denied. That's revenge, and it's stupid. And the longer we continue to do that, then the more money we're going to pay, and we're not buying ourselves one night of safer sleep. We're not buying ourselves any public safety. And we can beat our chest and pretend that we did this because of public safety. But it's revenge, and revenge is expensive, and I'm not sure how much of that we can continue to afford.
Thank you, Senator Wright. Senator Cogdell.
Well, again, I don't think that's what you're trying to accomplish here. You're just basically trying to make sure that people that are convicted under California law pay the penalty as prescribed by California law, no matter where they happen to be serving their time. So given that, I don't quite see it the same way as Senator Wright. But again, my issue related to the whole concern about the international treaties, and you've said you're willing to take an amendment and basically pare this bill down to where we're just providing another level of oversight, if you will, an actual eyes-on decision to be made by the governor on these. To me, that doesn't sound unreasonable. In fact, it sounds like good government to provide another level here before we make these decisions that are obviously important to each and every one of us and important to the prisoners and their families. So, again, I'm willing to make a motion to move the bill as the senators agreed to amend it, and would hope that we could give him a vote today on the bill.
So we do have a motion to amend the bill to narrow it to just have the governor be the final determining factor in these transfers, and so noted. With regard to that concept, I think it really deconstructs the entire reason we have a Board of Parole Hearings, which is appointed by the governor.
Absolutely, which in these cases, the Board of Parole has been ignored. They've said, no, do not release them.
That's not the case. In the transfer to Sweden, that was a decision of the Board of Parole Hearings.
Thank you.
So we do have a motion as amended, and if there are no other questions from the committee, you're pleased to make I hope you're happy, pleased to make a closing statement.
I'll be happy when justice is served and when we actually stand up for the rights of our victims in this state, because I believe whether it's 1 or 15, we can talk about it on both ends of the spectrum, those that are comatose in prison versus those that are cop killers that are being released. It's not about revenge. It's about sending a very clear message.
Senator, we'll take that as your close.
If you attack,
Senator, we'll take that as your close.
Am I being cut off on how much time I get to close? I only have a couple minutes.
If you'd like to take another 15 seconds, go right ahead.
Thank you. I think that it's important to respect our brave men and women that serve on the streets every day and send a very strong message that if you attack our police officers, then you're going to have to do the maximum penalty under the law. And that we ought to have transparency and oversight. So, again, I'm willing to pare this bill down to just that one small area of transparent oversight that our chief executive will sign off on every transfer.
Thank you, Senator. And we'll call the roll.
Leno?
No.
Leno, no. Cogdill?
Aye.
Cogdill, aye. Cedillo? Hancock? Huff?
Aye.
Huff, aye. Steinberg? Wright?
No.
Wright, no.
Thank you, Senator. Good, healthy debate. And so that bill will be placed on call for other members to be able to cast their vote before we conclude our work of the day. And I believe Senator Dutton is our next author. That would be our item number 10, Senator Dutton's SB 1265.
Yes, Mr. Chair. I'm here to present SB 1265, which actually is a result of a situation that occurred down in my district, an unfortunate situation for all involved. What this bill basically would do, this is sponsored, first of all, by San Bernardino County and the City of Upland, and is supported by the San Bernardino County Sheriff's Department. California manages what's called a Forensic Conditional Release Program, and this is known as CONRAP program. Recently, a CONRAP participant murdered another participant in a home in Upland that housed 7 individuals. It should be noted that this home also shared a fence with an adjacent school, elementary school to be more specifically. Under current law, to my surprise, the CONRAP programs are prohibited, the courts and the programs are prohibited from telling local law enforcement within the jurisdiction that the CONRAP participants will be placed in their areas. So they have no knowledge, and I've been told by the District Attorney's Office this is actually restricted by state law. Specifically, what this bill would do, this would allow local law enforcement to inform CONRAP. It would not make an absolute requirement, but it would allow them to do so. When a participant is placed in this jurisdiction, it also, this bill in its original format would limit the amount of occupants per home, although I understand the committee has some concerns about that, and so I'm willing to remove that requirement if it pleases the committee. And then also, I feel it would be important to also do something regarding the amount of distance, although I know there's some sensitivity about that, but true also the concern I've got is that this actual home was located right adjacent to an elementary school, and so I think there is some safety issues that we may want to consider with regards to that, but I think I am willing to obviously discuss that as well. And with that, I would request a favorable consideration. I do have with me today Tim Lynch, who's representing San Bernardino County, and then also Barbara Ferguson from the San Bernardino Sheriff's Department, and also a representative from the City of Upland to testify about the bill.
If you could hold just one moment before we proceed with those who want to speak in support and opposition.
I'm willing to accept.
Thanks for your patience. I just wanted to clarify so that we're all on the same page here as we move forward, both support and opposition, that our staff has been in discussion, and I think that you're addressing an important issue here, but that I would like your support in taking as authors amendments, first of all, that we would amend the residency restrictions out, and that secondly, we'd specify that CONREP may inform local law enforcement of the name and address of the CONREP patient, and that the other information then, of course, to be continued as confidential, and then amend the bill to specify providing notice pursuant to the bill would not relieve a program of any other statutory duty. So we're talking about SVP requirements, for example, that would not be touched. And then also we would clear that other duties will not be excused if a program provides notice under this bill.
Yeah, I discussed that with the sponsors of the bill, and they've agreed, along with myself, that we will accept these as authors' amendments.
Great, I appreciate that. And so I hope opposition also understands those will be the amendments. We're not talking about the bill as presented.
Correct.
We can proceed with those in support.
Tim Lynch on behalf of the Board of Supervisors of San Bernardino County and the City of Upland. First, to thank the Senator and the committee for working with us to move a bill that we still think accomplishes good public policy. As the Senator mentioned, this bill is the result of an incident that occurred in the City of Upland back in January. I think the incident caused a lot of people in the county and the City of Upland to scratch their heads and wonder what's the deal with this program. People weren't aware of it. We, quite frankly, hadn't paid too close attention to how it operated. As a result of that, the county undertook a pretty stringent investigation on what occurred with the incident, changed a number of policies and procedures in place internally, did public outreach with the community, with local law enforcement, and has been working with Senator Dutton to plug some holes in current law. Some of them that came out of our community meetings and meetings with other local officials now are being amended out of the bill, but we believe that the component to notify local law enforcement, or the ability to notify local law enforcement, is still very important, and appreciate that being left intact.
Great. Thank you, Mr. Lynch.
Good morning, Mr. Chair and members. Lieutenant Barbara Ferguson representing San Bernardino County Sheriff, and we're in support of the bill as it is to be amended. Thank you very much.
Thank you, Lieutenant Ferguson. Mr. Lovell.
John Lovell with the California Police Chiefs Association and the California Peace Officers Association. We're in support of the bill, and I would be remiss if I didn't commend your always excellent staff for fashioning this solution.
We appreciate that comment, always. Anyone else in support? And do we have anyone in opposition or want to make comments relative to the amendments?
Liberty Sanchez on behalf of the California Public Defenders Association. I believe I heard the amendments to remove the bulk of our opposition, and now the bill will be limited just to informing local law enforcement.
It's the notice provision.
Okay. Right. The only concern we would continue to have, and I look forward to working with the author and committee staff on this, is has to do with an issue we raised in our letter regarding existing Welfare and Institutions Code 5328, which provides for confidentiality of MDO and NGIs released on CONREP, and so I would just be interested to know how the amendment is going to be crafted.
Very good. Thank you, Ms. Sanchez.
David Warren, Taxpayers for Improving Public Safety. I was unclear from the comments as to the 2,000-foot limitation. Was that also?
The residency provisions were dropped.
Thank you very much. We withdraw our opposition.
Thank you, Mr. Warren.
Mike Carroll with the Western Center on Law and Poverty. We had the same concerns about the residency restrictions, and if they're out of the bill, our concerns are taken care of. We remove our opposition.
Very good. Thank you, Mr. Harold.
Evelyn Abu-Hassan with Disability Rights California.
I want to make sure you're there. I think it's on now.
Evelyn Abu-Hassan with Disability Rights California. Similar concerns to my predecessors here. I would have to take back the issue with the amendment just to check with our folks, but I think we're generally okay with the removal of the bulk of the language.
Good to hear. Thank you very much.
Thank you.
And Amanda Levy, California Psychological Association. Echo the comments of my colleagues. We'll take another look at it. We're concerned about the confidentiality in the residency, but we'll take a look. Thank you.
All right. Thank you, Ms. Levy.
There are some statutory notice requirements now that apply up to the point the person enters CONREP.
Senator Wright. Bill has been moved as amended. Any other comments or questions from the committee? Senator Dutton, if you'd like to close.
I would simply request an aye vote, and I want to thank committee staff for working with me on this. I think this is one of those issues that's not a partisan issue, it's just a common sense issue. And I want to thank you very much for allowing me to go forward with this bill.
Thank you, Senator Dutton. I want to thank you for bringing this to our committee. All these years that I've been chairing public safety, I was not aware that there was a prohibition to inform law enforcement of these individuals returning to their communities. So with that notice provision in place, I think we've got a strong bill.
Thank you.
We'll call the roll as amended.
Leno?
Aye.
Leno, aye. Cogdill? Cogdill, aye. Cedillo? Hancock? Huff? Huff, aye. Steinberg? Wright? Wright, aye.
The bill has 4 votes, enough to get out, but we'll put it on call so other members can cast their vote.
Thank you.
As amended. Okay. Senator Cogdill, if you'd like to take up your bill, which is SB 1060, and our item number 3.
Distinctions between these.
Right.
That's a little long, but...
Thank you.
Ready?
Senator Cogdill.
Thank you. SB 1060 would clarify the definition of pandering to specifically include people who recruit individuals who are currently engaged in prostitution. This clarification addresses a recent court ruling that broke from decades of case law by finding that pandering cannot occur if the recruit is already a prostitute. This new interpretation creates a loophole in the law allowing pimps to avoid punishment. Pimps must be held responsible for their actions. Prostitutes often suffer injury and abuse and sometimes even death at the hands of their pimp. This bill is necessary to make sure that pimps are held accountable for the powerful role they play in this dangerous lifestyle. I would like to thank the committee for considering this important piece of legislation and ask for an aye vote. And I'd like to, at this time, introduce Marty Veranakar.
That's correct, Senator.
Assistant CEO for the California District Attorneys Association.
Mr. Veranakar, welcome back to the committee.
Thank you, Mr. Chair. It's a pleasure to be here in the big room.
Yes.
And
I wouldn't argue that.
We're proud to be the sponsor of this important bill, and as the senator indicated, abrogates the holding of People versus Wagner and clarifies a situation where the person induced, persuaded, or encouraged by a defendant to engage in prostitution is currently a prostitute. The Wagner case involved a police officer posing as a John who observed a defendant trying to persuade a woman working as a prostitute to change her relationship and work for him instead. The defendant was convicted and sentenced, but upon appeal and overturning some 30 years of case law, the court reversed the decision and said the law only applied if the person sought to be induced, persuaded, or encouraged was not already a prostitute. I think this case basically stigmatizes the victim in this case, who happened to be in this instance a prostitute. Consider this scenario: the 15-year-old who was persuaded to engage in an act of prostitution for a pimp and is no longer enamored of the profession. She decides, is then approached by another pimp to work for him. She agrees to testify against him in the subsequent prosecution, but to no avail, because the defendant can merely defend himself by saying she was already a prostitute. I think this is a real anomalous situation. Is this a societal result that we want from the impact of this decision? And even the court in Wagner was uncomfortable and encouraged the legislature to clarify the statute, recognizing that for them to do so would be a violation of the separation of powers of the California Constitution. I think that there's one minor point that I do want to bring up. I do not believe that this bill should be subject to the ROCA policy, primarily because this is one case that put a gloss on a statute that had 30 years of case law behind it, and by enacting this bill and abrogating that case, we're just merely returning back to the status quo that we had. And with that, I would urge your aye vote.
Thank you.
John Lovell with the California Peace Officers Association, California Police Chiefs Association, and California Narcotic Officers Association. I really couldn't add anything to Mr. Vraniker's excellent statement. We're in support.
Thank you, Mr. Lovell. Anyone else in support of Senator Cogdell's bill? We'll allow those who are in opposition to come testify.
When he's talking about prior authority that was overturned.
Thank you, Senators and Senator and Chair and Mr. Leno and Mr. Huff. Matt Gray, on behalf of Association of Club Executives, we have not taken an official position. However, in the neutrality, we are concerned over not necessarily the latent intent of this bill, which we think is laudable. However, as current practice has it, some overzealous law enforcement have been going into adult nightclubs where they are lawfully operated businesses with security staff, security cameras, audio, etc., and citing performers, theatrical performers, for the act of simulated prostitution. While none of these arrests have actually resulted in any convictions or official charges being filed, it is a means of harassing these performers, and we are concerned that with this bill, the harassment would extend actually to the legitimate and lawfully operated businesses as well because of the encouragement words and the wording of this bill. So with that, there are some concerns, although we do understand that is not the intent of the author. Thank you.
Thank you, Mr. Gray. Anyone else in opposition? So I think this is a situation of our ROCA policy, and for those who are new to that acronym, that has to do with receivership, overcrowding, aggravation. And as we well know, we've got approximately 170,000 inmates, approaching 200% of what the prison system can handle. And so that this policy is in place so that our colleagues in both houses can begin to more seriously address this fact. We have the determination of a court that will do our job for us if we do not. They have told us we have limited time to reduce the prison population by 40,000. This, I believe, is very clearly the expansion of the scope of an existing wobbler. That's the purpose of it. And unlike the situation with Senator Padilla's body armor bill, which was held to be unconstitutional in terms of vagueness, there was no mention of vagueness in the Wagner case. In fact, in the Wagner case, the court was very specific, and they said that the legislature had taken, quote, pains to be precise in what it was prohibiting. So this is a very different situation from the body armor. And so I'm making the determination, of course, with the committee's approval, that this is a ROCA item. And whereas last year when we dealt with ROCA items, we had put them over until January to see if we, in the coming calendar year, would successfully deal with our overcrowding. But given that we're in the second year of our two-year session, rather than put it off for another couple of weeks, I'm happy to take the bill up to date, but I will be opposing it because of the ROCA concerns. I'm not arguing on the merits of the bill.
Well, and I appreciate your comments. I guess, obviously, we believe that's a bit of a stretch, quite frankly, given the fact that this situation was created by the court decision that we're trying to address here, and before that court decision, which I think took place after your ROCA policy was put in place. These folks would have been subject to prosecution. So, again, and this is, I'm assuming, a pretty small population, hopefully, as it relates to our overall situation with crowding in our prisons. So, again, I think it's a bit of a stretch to apply ROCA to this particular situation where we're really just trying to clear up a problem that's been created as a result of a court decision that I really think it's very difficult for anybody to understand, quite frankly. And it creates a situation in the law that I think is very unfair right now, depending on who you happen to be as it relates to the person that approaches you and tries to convince you to go into this line of work. And that shouldn't be the criteria, it seems to me. It's about the person that's trying to do the convincing, which is against the law, certainly as much as it is the individual that decides to go into that line of work or to work for a different pimp, if you will. So, again, I think the intent of the law is very clear, and I think this court case has certainly muddled those waters, to say the least, and that's all we're trying to do here. To me, it's a very simple situation that needs to be remedied, and again, doesn't have anywhere near the negative impact on our overcrowding situation that we might think otherwise.
Right.
Again,
And I just want to clarify.
Appreciate the opportunity to have a vote.
Sure. Senator Cogdill, again, I just want to underscore that I'm not arguing the policy with you, but it's my job as chair of the committee, which has taken on this ROCA policy, to be excruciatingly consistent in its application. When we as a committee collectively agreed to make a very narrow exemption for the body armor bill, it was on the issue of vagueness. And that's not the case in the Wagner situation.
I understand what you're saying, but just to correct the record and for history, when you say this committee agreed, Republicans have always opposed the ROCA policy from day one. And when I was on the committee as vice chair under Senator Romero, I was very adamant as it related to that issue. So just a minor clarification there, and to make sure that we're clear, Republicans don't support the ROCA policy of this committee.
Okay, I didn't say unanimously, but the committee did agree to make a very narrow exception in the issue of the body armor bill. So I'm being consistent to that. Senator Wright.
I have, and it might be a question to the chair of staff. If someone's seeking a conviction for pandering, pimping, I guess depending upon which neighborhood you come from, the crime, it seems to me, is that you have someone working for you as a prostitute. And it would not, I mean, I know a number of pimps who've been convicted, and they've had women who've been working for them for 20 years. Their crime was pimping and pandering, and it didn't matter whether or not she was recently turned out, or excuse me, that she was recently converted. So, I mean, as I look at the Wagner case, I clearly have facts that are not before me, because if he was guilty of pimping, the fact that she was a recent convert from another pimp would have been irrelevant to the fact that she was engaged in prostitution.
Go ahead.
Unfortunately, the statutory definitions of these crimes are very complicated. Pimping is technically deriving income off the work of a prostitute. Pandering can be proved in a number of ways. In Wagner, the defendant was charged with inducing a person to become a prostitute. The court found that that doesn't apply if the person who was induced already was a prostitute. There are other ways to prove pandering that apply where the person who was induced or encouraged was a prostitute at the time. That is where you bring someone into a house of prostitution or procure them for a particular sexual liaison. So these things, as the court noted, were written in the 1870s, and it's proof that the legislature can write very detailed, confusing laws whenever it wants to. But you're right that that defendant Wagner, if they could prove that he actually made money off of prostitution, would have been guilty of pimping, but that's a separate crime than pandering.
See, the concern I have is that and I'm speaking now to the policy separate from ROCA, if the prosecutor was incompetent, that's not Mr. Wagner's fault. There are a number of ways that that person could have been prosecuted for pimping and pandering without changing the elements of the law. They simply chose a way that clearly was in violation of the statute, which is why Mr. Wagner beat the rap. If they had filed the case properly, then Mr. Wagner would have properly gone to jail as he should have. I'm not sure that we need to adjust the law because you had an incompetent prosecutor in one area of the state. He should have filed a proper case, and Mr. Wagner would have been properly convicted.
Well, it does appear from the facts of Wagner reading that case that the prosecution had evidence that he was a pimp for a number of other women. They picked his cell phone up and recorded conversations or talked to other women who were his prostitutes. So I don't know why they didn't charge him with pimping. I think they had the evidence to do that.
Point well taken, Senator Wright. With no other questions before the committee, I'm going to accept Senator Huff's motion to move your bill. And I will be opposing it, as mentioned, as a result of our ROCA policy and being consistent with it and to it. So we will call the roll.
Leno?
No.
Leno, no. Cogdill? Aye. Cogdill, aye. Cedillo? Hancock? No. Hancock, no. Huff? Aye. Huff, aye. Steinberg? Wright?
No.
Wright, no.
There's still member 2 missing from the committee, so we'll put that bill on hold. It has 2 votes and needs 4. Thank you, gentlemen. Okay.
That was fun. Thank you.
Thank you, Jerry.
You never know what's going to come out of your mouth. It's got some
I thought I had my... Committee members, we just have a few more bills on our agenda. We have Senator Cedillo to present his SB 1331. I think he's at another committee hearing right now, but would ask that he would come down. And then I'm going to now, and then also we have Senator Cedillo's 1190 as well. And then the last 2 committee bills, our committee bills, items 7 and 8, which I will now present.
All right, Mr. Leno, you're submitting, or you're presenting item number 7 and 8 for the committee?
Right. Thank you, Mr. Chair.
Please proceed.
The legislature put into motion through the Law Revision Commission a review of what is recognized fairly universally as our very complex and confusing statutes which regard control of deadly weapons. And so the effort was to make it more user-friendly and readily understandable without changing their substance. These 2 bills, SB 1080 and 1155, have done just that. They are the result of this multi-year study. So the bills would benefit the state by making it easier for law enforcement officers as well as prosecutors and defense counsel, courts, and gun owners and gun control advocates to better understand and follow the law. And Barbara Gall, Chief Deputy Counsel of the Law Revision Commission, is here to answer any questions of what is a very couple of thick bills because they impact so many different statutes over the years.
Okay.
I'm Barbara Gall. I'm happy to answer any questions you might have.
Okay. Any other comments from supporters?
Mr. Chairman, Ed Wardy with the National Rifle Association. Our legal counsel has been watching this process and participating with the Law Review Commission all the way through the process. So I've attended the hearings and worked with their staff very closely, and we're supporting the modification and the cleaning up of the penal code.
Okay. Thank you.
Mr. Chairman, Tom Pedersen, California Rifle and Pistol Association. We've also been monitoring this and working with staff, and we're also in support of the bill. Thank you.
Right. Thank you. Okay, thank you. Any other witnesses in support? Any witnesses in opposition? Seeing none, any comments from committee members? All right. Thank you, Senator Hancock. The bill has been moved. If there aren't any other comments, please call the roll.
Leno?
Aye.
Leno, aye. Cogdill?
Aye.
Cogdill, aye. Cedillo? Hancock? Hancock, aye. Huff?
Aye.
Huff, aye. Steinberg? Wright? Wright, aye.
Okay.
Do we need to take up the second bill?
Does that bill have sufficient?
Motion for 1115.
Right. Okay. Do you want to take up the second bill? Just call the roll.
Make a motion.
Okay, we need a motion on item number 8, SB 1115.
So moved.
Moved by Senator Hancock. Please call the roll.
Leno?
Aye.
Leno, aye. Cogdill?
Aye.
Cogdill, aye. Cedillo? Hancock? Hancock, aye. Huff? Huff, aye. Steinberg, Wright?
Aye.
Wright, aye.
Those bills have sufficient votes.
Committee members, as mentioned, the only two bills left to be heard today are Senator Cedillo's two bills, items 9 and 11, so I know the sergeants are trying to reach him right now. And Senator Hancock, we may lose shortly, so we're going to lift the call on all the bills so you can cast your votes, and hopefully Senator Cedillo will get here in time to present his bills today. So we'll start from the very top. That would be item number 1, which we have put over to continue working. Item number 2, also Senator Ashburn's we have put over to continue working with him. So item number 3, Senator Cogdill's SB 1060. Lift the call. Call the roll, please.
Cedillo? Steinberg?
So we can replace the call if you like, Senator Cogdill. We'll move on to item number 4, which is Senator Oropeza's 1066. Call the roll, please.
Cedillo? Hancock? Aye. Hancock, aye. Steinberg? Wright? Aye. Wright, aye.
That bill has 5 votes, and we'll keep that open for Senator Cedillo, so we'll replace the call. Item number 5 is Senator Oropeza's 1067. If you could lift the call, please.
Cedillo? Hancock? Aye. Hancock, aye. Steinberg?
That bill also has 5 votes, but out of respect for Senator Cedillo, we'll replace the call. The next bill is item number 6, Senator Denham's SB 1078. And that was as amended. Chair voted no. Lift the call, please.
Cedillo? Hancock?
No.
Hancock, no. Steinberg?
Again, that bill has 2 votes. We'll replace the cap. 7 and 8 we've just voted on. 9 is Senator Cedillo's. Item number 10 is Senator Dutton's bill, SB 1265, as amended. If you could lift the call, please.
Cedillo?
Aye.
Cedillo, aye. Hancock? Aye. Hancock, aye. Steinberg?
So that bill has 6 votes, 6-0, and it is out. Senator Cedillo, we welcome you to the committee. You have 2 bills with us, item 9 and item 11. Why don't we start with 1190?
Mr. Chairman, my apologies. I've been in several committees and chairing
Senator,
a meeting.
Excuse me just one moment.
Yes.
Given Senator Hancock's need to leave the committee, why don't we start with 1331, item number 11.
1331, the Racial Justice Act ensures that justice remains blind in our society. We are concerned that people are being sentenced to death because of discrimination in our society. I know that every single person in this room abhors that thought. And so what we're doing here, and I've had this conversation with everyone, no one would want to suggest, wherever you stand on the question of the death penalty, that someone should receive the death penalty because of someone's sense of discrimination or bias that they bring either into the jury or in the pursuit of justice in pursuing the case. And so to that extent, we've brought forth 1331, which simply brings an opportunity for the defendant to raise a claim that they believe that the result is a product of discrimination, and therefore the jury or the judge, they have an opportunity to review additional information that gives them a different perspective to ensure that in California people are not given the death penalty as a result of their ethnicity, of their race, or any other bias that someone may bring into a jury or a judge or in the pursuit of this case.
Thank you, Senator. And I know that you're basing this on the success of a similar program in North Carolina
Yes.
and Kentucky.
Those bastions of liberalism.
Yes, and just so, again, we're all on the same page as the testimony is being made, as the analysis pointed out, most of those on death row do not have habeas counsel. And so whereas your bill currently is drafted that there would be the opportunity for those who do have counsel 3 years' time, that for those who don't, we ask that you take an amendment that the 3 years would start once the counsel is obtained.
That's completely rational and reasonable.
Okay, so that would be an author's amendment.
Embrace that.
Very good.
Right.
Wants to make it do pass a motion. Do you want to make a motion?
Senator Hancock?
Yeah. I read the bill and understand the concept, and I'm in favor of it. I would move the bill.
Oh, you can't take testimony.
We can't take testimony after a motion is made, so...
Oh, well, then I won't.
All right, okay. Thank you for the author's amendment, and we will proceed with those in support.
Hi, my name is Sarah Jackson, and I'm a staff attorney with the Equal Justice Society, and we're the organizational sponsor of SB 1331. EJS is a national legal organization that works to advance civil rights and racial justice, and one of our goals is to inform public discussion on race and racism in the law in hopes of identifying and eradicating race-based discrimination. And we're aware that discrimination, both intentional and unintentional, exists in many facets of our society, including and often especially in the criminal justice system. And SB 1331 we see as an important way towards identifying and eradicating racial discrimination in this system, and that's why we sponsored it. As Senator Cedillo mentioned, I think it's important to emphasize why SB 1331 is necessary in California. A recent study by Radelet and Pierce, which is the first study of race and ethnicity and geography in California death sentencing, found that although only 27% of California murder victims are white, over 80% of executions in California have been for those convicted of killing whites. For decades, African Americans have been overrepresented on death row, and in recent years, more and more Latinos have also been sentenced to death. And likewise, a recent study released by the ACLU found that Latinos comprised a staggering 50% of new death sentences in 2007, and between 30 and 40% in both 2008 and 2009. And this is a huge increase. Back in 2001, for comparison, Latinos comprised only 16% of those sentenced to death. And we feel that these statistics are unacceptable and that California can and must do better. SB 1331 is about making sure that the death penalty in California is administered fairly and without regard to the race of the defendant or the race of the victim. A death sentence once carried out is irrevocable, and SB 1331 is essential to ensure that this sentence is prescribed to punish the perpetrator of a grievous crime and not to satiate the bias of any prosecutor, jury, or judge. Some critics have argued that we haven't had problems with this in California, but we haven't also had the opportunity to fully litigate this, and that's what SB 1331 will allow us to do. It provides a defendant with the opportunity for meaningful review of their record and record of their sentence if they believe that it was tainted by racial discrimination. It won't eliminate the death penalty, and it also won't allow a defendant to go free or receive a sentence lower than the statutory minimum. The sole purpose is to make sure that no death sentence in the state of California is racially motivated. We hope you'll support this bill.
Thank you very much. Others in support?
Yes, my name is Andre Herron. I am a practicing attorney who began my career as a prosecutor in another state, and I now work as a death penalty appellate lawyer here in California. The day after Barack Obama's election, the Wall Street Journal published an editorial in which the writer opined that perhaps with the election of Mr. Obama, we could finally put to rest the myth of racism in the United States. And with that single turn of phrase characterizing racism as a myth, the author unwittingly proved that which he so inartfully tried to deny. If we think that we have entered a post-racial era in the United States, we need look no further than the shameful display of ignorance and racism that took place in the nation's capital a mere 2 weeks ago at the height of the health care reform debate. People spat on congressmen and yelled racial epithets in a frighteningly retrograde incident that was reminiscent of the days when segregationists defied the federal government's efforts to eradicate racial inequality, and at the same time was deeply reflective of the long-standing and well-ensconced legacy of racism in this country. Racism is embedded in America's character, and the criminal justice system is its greatest purveyor, demonstrating time and again that the factor of race colors, no pun intended, the entire process. The death penalty is its most sinister tool, and like many of society's ills, it falls with unrelenting consistency on our most disadvantaged and disenfranchised citizens. There are those who genuinely believe that people of color are disproportionately represented in the criminal justice system because they are bad people, less moral, and to hear some tell it, possessed of a criminal gene that renders them more likely to offend the law. But from cradle to grave, people of color are surveilled more, stopped more often, scrutinized more closely, demonized, and sentenced more harshly than are whites in this society. The statistical studies you have heard about confirm what people of color have always known, that the system has an uncanny penchant for capturing them at its sweep. Given this reality, we cannot bury our heads in the sand and act as though racism doesn't exist because we think ourselves well-meaning people in a society governed by the rule of law. Knowing what we know about the legacy of racism in this country, we must act to ensure that every step is taken to eliminate racism as the most dominant factor in the criminal justice process. SB 1331 is a step in the right direction. I've served as a district attorney and as a criminal defense lawyer. As a DA, I experienced racism within my own ranks, and as a criminal defense appellate lawyer, I have reviewed records where DAs repeatedly strike people of color from juries for reasons such as lack of supervisory experience or some other weak subterfuge to mask their true intent. Similarly, I have seen disparity in the treatment of black-on-black crime versus black-on-white crime, squarely implicating the judicial function as yet another juncture at which racism rears its ugly head. One particular incident comes to mind. When I was working as a DA, a case came through my office involving the murder of a black woman by her husband. She had been the victim of repeated domestic violence involving ever-escalating incidents, one in which her husband cut all the tendons in her hand. Yet none of these charges ever resulted in a felony prosecution until he finally killed her. He was charged with second-degree murder, and bail was set at $30,000. Around this same time, a white female attorney was abducted from her office and gang raped by several black men. They were arrested and charged, and their bail was set at $5 million. Now, I do not believe that either of the judges involved in these decisions deliberately intended to convey the message that is so evident on the face of it, that a white woman's honor is more sacred than a black woman's life. But the average layperson would be hard-pressed to divine any other meaning from the discrepancy in bail set for these cases. If there is any myth about racism, it is the notion that well-meaning white people have somehow miraculously escaped the beliefs and attitudes about race that are hardwired into the American psyche. This is why claims that SB 1331 demonizes prosecutors and brands them as racist are sophistry. We must disabuse ourselves of the notion that racism only happens down south and is what people wearing hoods and burning crosses do. That conduct is racism, to be sure, but it is also alive and well in the courtrooms and boardrooms of this country where life-changing decisions are made. And as Malcolm X once noted, South is anywhere south of the Canadian border. If we insist on continuing to use the fiscally irresponsible and morally untenable system of capital punishment, we owe it to ourselves to do everything humanly possible to eliminate the overt and subtle vestiges of racism reflected in that system. If, as some believe, California's death penalty system is free from racial bias, it should be able to withstand the scrutiny contemplated by Senate Bill 1331. In closing, this committee should know that on California's death row sits a black man who has been there for nearly 20 years, if not more, for a crime involving the murder of a live-in babysitter. One child at the scene described the assailant as a white man with a white mustache. Another insisted that the black man didn't do it. And yet there he sits, closer to death than to exoneration. The question I would like each of the committee members to consider when making their decision on SB 1331 is this: where in the United States do you think a white man would sit on death row for nearly 2 decades if any witness said that a black man did it? If you are honest, the answer to that question makes clear what you must do. As stewards of the public trust, you must be unwavering in your commitment to equal treatment under the law. The passage of SB 1331 will move us closer to the day when justice, not race, is the dominant factor in the criminal justice system. I urge the committee to act favorably upon this bill. Thank you.
Thank you very much for your testimony. I'm going to ask everyone if you could give your name and identification, and if you feel you must say more, make it as very brief as possible.
Natasha Minsker on behalf of the American Civil Liberties Union. We are in support.
Thank you very much.
Stephanie Fauché, Associate Director for Death Penalty Focus. We have more than 25,000 supporters in California, and we are strongly in support of this bill, and we sent a letter in support.
Thank you very much.
Liberty Sanchez, Public Defenders. Liberty Sanchez, Public Defenders Association, in support. I'm just really glad the second witness switched sides to the defense side.
Thank you, Ms. Sanchez.
Jim Lindberg, Friends Committee on Legislation of California, in strong support.
Thank you, Mr. Lindberg.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support. There are existing statutes to remedy racial discrimination, pattern of discrimination when it comes to law enforcement practices. We don't have something equivalent for the death penalty. This would move us in that direction.
Thank you, Mr. Hernandez. Also in support.
Linda Warner with the Catholic Conference, in strong support.
Thank you, Ms. Water. Anybody else in support? Senator Cedillo's 1331 will allow the opposition to come forward.
Good morning, Mr. Chair, honorable members, Senator Cedillo. With all due deference to your bill, this is difficult for me to.
Sir, if just for formalities, if you could introduce yourself.
Marty Varanakar. I'm sorry, sir. You've supported many bills that we have carried in the past regarding gangs and gang legislation. We appreciate that, but on this bill, we must state our opposition. I think it's because the decision to seek the death penalty is reserved for the most egregious crimes that we have in this state. And that decision is often the most important and solemn decision that a district attorney faces, given the finality of the potential judgment. In that regard, most district attorneys in this state have adopted death penalty review policies and procedures. That death review teams involve the district attorney himself, senior staff, often as chief investigator, and the trial attorney. And they closely review the facts, the defendant's criminal history, carefully weigh the mitigating and aggravating circumstances, and often obtain input from the defendant's counsel before a decision is made. The statistics cited by the proponents can be often misleading, and I'll address specifically the one study or the one statistic that was cited, that 80% of the executions here in California were of a particular race. The bar, however, under this bill, the bar for a pre-conviction or post-conviction hearing to challenge either the charging decision of the DA or a death penalty judgment is set extremely low. Only one factor of the three enumerated in the bill is sufficient to challenge either the judgment of death imposed after a lengthy trial or the DA's filing decision to seek the death penalty. The question is whether or not this provision in and of itself runs afoul of the separation of powers within the California Constitution. There are already procedures in place to combat many of the issues raised by the proponents. There is extensive jury voir dire to weed out bias, Wheeler motions to attack an alleged race-based peremptory challenge to a juror, and Murguia motions to challenge discriminatory enforcement by law enforcement in making the arrest. This bill, unfortunately, indicts our entire criminal justice system and presumes that in death penalty cases, the system is biased. This bill also presumes that jurors somehow cannot set aside individual biases when they vote for death instead of life without parole. Death penalty cases over the years since it's been reinstituted have been overturned for any of a number of reasons: evidentiary errors, incompetence of counsel claims. But in the 30 years since the death penalty has been reinstated, there has never been a finding of prosecutorial abuse in the decision to seek the death penalty. And no death penalty case has been overturned on a finding that the prosecutor had an improper motive based on race, bias, or vindictiveness in making that decision. Since 1978, California has executed only 13 people. 10 of those people were Caucasian, 2 were African American, and 1 was another ethnic background. For these reasons and more, we urge you to vote no on this measure. Thank you.
Thank you, Mr. Ranakar.
Yes.
Thank you. Dawn Kepke with McHugh & Associates on behalf of Crime Victims United of California, also in opposition to this measure. And I can't seem to add anything more than Mr. Ranakar. He did a great job and covered all the points that we would echo as well. Thank you.
Thank you, Ms. Kepke. Anybody else who'd like to speak in opposition to Senator Cedillo's bill? Questions, comments from the committee? Senator Cogdill.
Thank you very much. Just a question relating to the system of the state of California. You mentioned the number of inmates that have actually been put to death since 1978. I think you said it was 13. Is that correct?
13, yes.
And how many people do we have on death row right now, do you know?
I didn't view the statistics, but there are quite a few individuals that are currently on death row within California.
If I may, I actually have the numbers that I printed off of the Department of Corrections website last week, and it's just about 700.
700. Do you know what the average time spent?
I'm afraid it does not break down that time frame here. I think on the whole, we're looking at a couple of decades for many of the cases.
As it relates to the appellate process in the state of California on death penalty cases, how do we compare with other states in the nation that have the death penalty?
In terms of how long it takes to finally reach execution.
Yeah.
I think that California is certainly one of the states that affords a lengthy process, both of appeal and habeas proceedings. It takes quite some time.
And
I'd say over 30 years.
Right. If I understood your testimony correctly, you're saying that the concern that the bill addresses is already an issue that can be considered in appeal, but that there haven't been.
Many of these same issues that are raised by the proponents are brought up in habeas proceedings, or in other proceedings. As an example, Wheeler motion. If there's a challenge to a peremptory by a prosecutor on the basis of race, a judge has to review that situation, has to make a determination whether or not it was race-based, and then and if a judge so finds at that time, then another jury is impaneled.
Okay. But did I understand you correctly that that's never been found to be the case in the state of California?
No, what I'm saying is that it's never been found that a prosecutor presented a case or issued a case seeking the death penalty that has been found or overturned as a result of race, bias, or some sort of vindictive motive.
Okay.
That's what I'm saying.
Right. Thank you.
Thank you, Senator Cogdill. Senator Huff.
So if we've put to death 13 and 10 of those were white, would that indicate we have a bias toward executing white people according to this bill? Or
questions addressed to?
I'm not sure how to address that question, Senator.
Well,
it's just the numbers. I think the point is that when people throw out numbers, when people look at statistics, I think that they could be used for a variety of reasons, and can support many times different outcomes depending on which way you want to frame the situation.
And I recognize this is a sensitive, it's a sensitive subject. My concern primarily, I certainly have no problem with the first premise here that no person shall be condemned to death or shall be executed pursuant to any judgment that was sought or obtained on the basis of race. The problem goes to how you determined that it was done on race, and I specifically have a problem with using statistics, because statistics reflect a group of, it correlates together, it groups together data that is not necessarily related, but we then take that data and we make decisions based on it or make predictions. I know that golden retrievers are less aggressive than, and I'm not drawing any racial, examples here. I'm just saying from using something totally separate. Golden retrievers are very docile. That's why I bought a golden retriever for my kids when they're young. I did not get a pit bull. But if you looked at it statistically, you're going to see that pit bulls are more aggressive than golden retrievers. The statistics is a poor indicator there. Certainly human behavior is much more complicated than it is with dogs. And there again, it's not a good metaphor, but I was just trying to think of something that that you can apply statistics evenly to that doesn't come out with an even outcome, because there are other complicating factors there. And so I do have a problem with using statistical evidence, which your bill allows, to demonstrate that this has created a racial inequity. So, there's some other issues I have that were articulated by the witnesses as well, but that's the primary thing for me. So I will not be able to support your bill.
Thank you, Senator Huff. I have a question for the proponents. The bill states that the defendant shall have the burden of proving a preponderance of the evidence that race was a significant factor in the decision to seek or impose a death penalty. Non-attorney preponderance evidence, I know that's not beyond reasonable doubt, but it still seems like a rather high bar. How does this work, and do you know how this compares to the mechanics in North Carolina and Kentucky?
And if I could also just clarify a couple of the other points that were raised. This bill would empower the judge to hear all of the evidence in each individual case and make a determination based on the facts of that case. It's much like a bill that was heard earlier today. It simply allows the defendant to bring a motion and put all of the relevant evidence in front of the judge, and then the judge makes the decision. The standard that we have placed in this bill, the preponderance of the evidence, is actually higher than the standards in other state bills, but we decided that was something that was appropriate. Higher than in other states, appropriate for the state of California. The statistical evidence would be relevant, but the other side would be able to put their own statistical evidence in and would be able to put in any kind of other evidence in rebuttal. The bill would prohibit discrimination on the basis of race and death sentencing on the basis of race for anyone. And so if it turns out that the state of California is more likely to execute white people, that is actually a problem. And that is a problem that this bill would address, and something that I think the people of California don't want to continue. And lastly, many of the motions and protections that the representative of the District Attorneys Association cited are relatively new protections that are in place only at the trial level. Many of the people on California's death row, like the witnesses referred to, have been there for 30 years, and they were sentenced to death at a time when the laws in California were very different. And many of them have never had a full and fair opportunity to address the problems that occurred in their trials.
Thank you very much. Senator Wright.
One of the things I guess we're not discussing is whether or not the person did it. So let's suppose we have a discussion and the defendant says, yeah, I cut his head off, but I think I was only given the death penalty because I'm black. There's two parallel sets of issues, I think, that go forth. I'm clearly concerned if we execute someone who didn't do it because you don't have an opportunity for a do-over. At the same time, again, if I go to the communities that I represent, I have a whole lot more murders in Compton than I do in Palos Verdes, and I represent both of them. So if I were using statistics, the likelihood that someone would be charged with a capital crime is greater for a guy in Compton than it is in Palos Verdes, because there are not nearly as many murders that occur in Palos Verdes. So if I were applying the statistical argument, then no one would ever be charged, because disproportionately the people who get convicted come from areas where crime is going to be more prevalent. I mean, I'm much more concerned about the case where, as one of the witnesses brought out, where there's a good chance that the person didn't do it. And there my concern is less about the ethnicity than the innocence of the person being charged. But if we simply have a preponderance of evidence based on a statistical analysis, then you could create a vehicle by which no one ever received the death penalty, because at some point you could say that race created the poverty that caused the person to live in the Nickerson Gardens housing development, and therefore had he not been in the projects, he would have not been in the environment that caused him. I mean, I'm not sure that I haven't studied the entire bill, for which I apologize, but I'm not sure where the preponderance begins and ends for the claim that you would make that you shouldn't receive the death penalty. I guess where I may differ from some of the people who testified is that most of them would be opponents to the death penalty on its face. I'm not. And I say to people all the time that I have absolute proof that the death penalty does, in fact, persuade some people not to do murders. That person won't do it again. I don't know whether or not it will influence his friends, but I can be assured that that person won't do it again. But that said, I'm still concerned that we not execute innocent people. So my question after all of that would be, given the discussion of the preponderance of evidence, we're no longer looking at the issue of guilt or innocence. We're now switching to the circumstances upon which the conviction was made. That gives me pause, because I'm not sure that you couldn't ascribe a whole series of socio-environmental factors that created the crime, at which point no one would ever receive the death penalty.
If I might respond briefly, 2 points. First, there's only one study that's been done on the death penalty and location in California. That study was done in Alameda County, and it hasn't been published yet. But the preliminary findings actually are contrary to what you just supposed, that in fact the death sentences are more likely to be pursued in white neighborhoods where the homicide rate is relatively low, and are almost never used in the African American neighborhoods in Alameda County where the homicide rate is very high. So this is again about the way in which the death penalty is applied unfairly, in a way in which we too often actually reflect a different valuing of the victims, and white victim cases are often given preference and more resources than the majority of murder victims who are African American and Latino. The second point briefly is that innocence and racial justice are intertwined. The most common cause of wrongful conviction is mistaken eyewitness identification. The most common cause of mistaken eyewitness identification is cross-racial ID. So these are two issues that are intertwined.
But again, I mean, we won't debate it, and I haven't seen the study that has not yet been released. But the issue becomes, again, looking at crimes as I do in communities that I represent, again, say Compton, Watts versus, say, Palos Verdes or Westchester. Clearly, you're going to have, I mean, I'm certain that you're not saying that there are more people convicted of capital crimes in Palos Verdes than, say, Compton.
I haven't done the research on those neighborhoods, but I can say in Alameda County, where I live, there are more people convicted of capital crimes that originated in predominantly white neighborhoods than are convicted of capital crimes in Oakland.
So, and again, the perpetrator of the crime would be a person who, say, lived in East Oakland and committed the crime in, say, Piedmont, or is that the circumstances of the crimes are all different. The perpetrators are all different. What is consistently the
studies consistently show disparity in terms of the race of the victim. And so what is consistently shown is that if the homicide victim is white, if the homicide victim lives in a predominantly white neighborhood, which is often correlated with being a wealthier person, then it is much more likely that the death penalty will be sought no matter who the perpetrator is.
So the issue, so in purposes of this, excuse me, so for purposes of this bill, could I argue then that a person should get the death penalty because they committed a crime that statistically would have fallen the other way? So could I argue as the victim or a survivor of a victim in a crime that he should get the death penalty because he's not getting the death? I mean, does this bill swing both ways? Could I argue in favor of the death penalty because the person is being let off because they were black?
Senator Wright, I don't wish to cut you off. At the same time, it's already 12:30, and we've got caucuses to attend to and other business of the day. I think your answer to that question has already been made in response to Senator Huff's question. Yes, this is about racial justice across the board.
So
we want to take the issue of race out of the determination of pursuing the death penalty.
The victim could, in fact, argue that the death penalty should be applied.
Of course.
Okay.
Of course.
All right.
Absolutely.
So, I think public has spoken. We have any other questions from the committee? I'm going to I'm going to move the bill as amended with the author's amendment. And Senator Cedillo, if you'd like to close.
I thank you for your time and attention and patience with the bill. I enjoy my good relationship with the DAs throughout the state, LA County specifically, and the city attorneys throughout the state. I don't take this up lightly. This is not a bill that is designed to have any animus or hostility to the hard work of district attorneys, and I enjoy working with them in the pursuit of justice. But for them, I think it's critical, and for all of us, as Senator Wright was indicating, that we take a victim's perspective and that we look at this to make sure that no one is given the death penalty, given that that is irrevocable because of race, or not given because of race, that we should look at the facts and circumstances. And that is the circumstance and situation that this bill attempts to move our society towards. I ask for an aye vote.
Thank you, Senator. I appreciate your bringing the bill forward. I think we should all be concerned, no matter who we are, where we live, what communities we represent, that there is justice across all racial lines, and I think that's the very purpose of the bill. Yes, statistics can be used, we know, to make any kind of conclusion we may wish to conclude. At the same time, I think that there are situations where statistics are rather compelling and that they can't not be ignored. So I think the way your bill is constructed allows for a case to be made and for the rebuttal to be heard as well. And I was actually encouraged to hear that the bar is higher in your bill with a preponderance of evidence rather than that which is found in the Kentucky and North Carolina statutes. I haven't heard anything from either side that there's any problem with the statutes that exist in those two states. I'd be pleased to join you, given that we're amending the bill to be a co-author. And with that, I ask that the roll be called.
Leno?
Aye.
Leno, aye. Cogdill?
No.
Cogdill, no. Cedillo?
Aye.
Cedillo, aye. Hancock? Huff? Huff, no. Steinberg? Wright?
We will place the bill on call. We're missing members. And if we could, with as much expedition as possible, to conclude with your SB 1190, which is item number 9.
Members, this is, the hour is late. It's very straightforward. We're trying to create a uniform standard for the issuance of clubs or batons for animal control officers.
Very good. Thank you. Those in support?
John Lovell, California Police Chiefs, California Peace Officers, in support.
Thank you, Mr. Lovell. That was brilliant.
Liberty Sanchez on behalf of Laborers Locals 777 and 792, representing animal control officers in support.
Thank you, Ms. Sanchez.
Aaron Reyes, President, CACTA, the California Animal Control Directors Association, in full support.
Thank you, Mr. Reyes.
Sergeant Marty Shirey from Santa Ana Police Department. I am in full support, mainly because at the current point in time, I've been supervising my unit for 9 years. I'm not exactly sure if I'm in compliance with the law because I currently have my officers post-certified with post-certified instructors. However, according to the law, it states that I'm supposed to go through the Consumer Affairs Department. So.
Thank you, Sergeant. Anyone else in support? Anyone in opposition? I thank you, Senator. I don't think there's any need for batons to be called bite sticks when they're batons. I think your bill will correct that situation. We have a motion by Senator Cogdill, and we'll call the roll.
Leno?
Aye.
Leno, aye. Cogdill?
Aye.
Cogdill, aye. Cedillo?
Aye.
Cedillo, aye. Hancock? Huff?
Aye.
Huff, aye. Steinberg? Wright?
Aye.
Wright, aye.
That bill has sufficient votes to get out. We're going to place it on call for just a few minutes as we assess the situation. One moment, please. We're going to lift a few calls here, mostly for your benefit, Senator Cedillo. So we're going to start with item number 3. Items 1 and 2 have been put over. Item number 3, SB 1060 by Senator Cogdill. If you could lift the call, please.
Cedillo?
No.
Cedillo, no. Steinberg?
That bill fails 2-4.
Oh, great.
Wonderful, thank you. We'll move on to item number 4, which is Senator Oropeza's 1066. If you could lift the call, please.
Cedillo?
Aye.
Cedillo, aye. Steinberg?
That bill is out 6-0. Moving on to item number 5, Senator Oropeza's 1067, as amended. If you could lift the call, please.
Cedillo?
Aye.
Cedillo, aye. Steinberg?
That bill is out 6-0. Item number 6, Senator Denham's SB 1078 as amended. The chair had voted no. We'll lift the call, please.
Cedillo?
No.
Cedillo, no. Steinberg?
That bill fails 2-4. Item 7, SB 1080, the committee bill. Lift the call, please.
Cedillo?
Item
7.
1080?
1080.
Cedillo, aye.
Cedillo, aye. Steinberg?
That bill is out 6-0. Item number 8, SB 1115, also committee bill. Lift the call, please.
Cedillo?
Aye.
Cedillo, aye. Steinberg?
That bill is out 6-0. Item number 9 we've just voted on. We'll lift the call. SB 1190.
Hancock?
Chair voting
Aye.
aye.
Hancock, aye. Steinberg?
That bill is out 6-0. Item number 10 was already out, 6-0, as amended. And then item 11, Senator Cedillo's SB 1331. Lift the call, please, and that's as amended.
Hancock?
Aye.
Hancock, aye. Steinberg? Wright?
That bill has 3 votes. We'll replace the call for the moment. And committee members?
Right, aye.
Oh, right, okay.
Wright, aye.
Right, aye is 4-0. That bill is out. 4-2, I'm sorry. That bill is out. I thank everyone for your patience, participation today with no other business before the committee. We are adjourned.